Dobry ranok. Good morning. So today we are starting our interview session with the candidates for the position of the head of disciplinary inspector service from Mr. Vladislav Lipivsky. Good morning, Mr. Vladislav. So first of all, let me introduce our commission. Today we are all 6 of us. I'm Reda Moliene, the chair of the commission, and here are commission members: Yulia Bokova, Olena Kovby, Olha Popikova, John Ehrlich, and Pavel Zelinchik. Probably you already know how the interviews are proceeded, but let me remind you that we will start from your short presentation, introduction, and presentation of your vision and motivation. Why are you going for this position? Then we will have the session of questions. First of all, the questions regarding your professional competence and skills, and also managerial competence. And the second set of questions will be related to the integrity. And at the end of the interview, you will have several minutes for your final comments if you want to do so. The interview is broadcasted, and if you have any information which falls under restriction for its public disclosure according to martial law, please inform the Commission during the interview at any time, and we will make the decision accordingly. Also, one technical aspect that we are kindly asking our candidates to speak slower, because our interpreters have to translate accurately what you are telling us. And would you have any requests regarding the composition or any other? No requests. So then we could start our interview. Yes, one more detail, that the interview will last for approximately 1 hour. It can be extended for 10 or 15 minutes if necessary. So the floor is yours for your introductory presentation, please.
Good morning, dear members of the Competition Commission. It's very I'm very delighted to be here. Thank you for being so fast and operative in conducting such a complicated competition in difficult times in the country. I prepared a short presentation. I will briefly introduce myself, why I see importance in launching this service, my vision on the functioning of this service, and the first steps to be applied. I understand that members of the Competition Commission already studied my dossier as a candidate, but because this interview is broadcasted for outside observers, I want to mention my previous experience that brought me in here. Briefly about myself. I am one of the youngest candidates for the position of the head of SDI, but I have approximately 15 years of professional experience, which I was founder of a company, I was legal consultant, I was head of legal department, I was a lawyer as a private entrepreneur, but I want to emphasize my experience, which influenced me most is my experience of serving public service. The day when I swore the oath of the public servant, I will remember it. It was a difficult time for the state. I was swearing public officer's oath on February 24, 2022, when the full-scale invasion started, and I got challenges from the first day of my work. They were significant. I had no previous experience of because I had to organize activities of the department which I was head of, which I was not introduced to the team location, like like and I didn't know about locations, like because I was the head of the department of complaints of the state executive service. So like the deadlines for preparing answers to the requests, they're defined by the legislation, and here it's important to properly, thoroughly, and timely prepare such replies. So I want to mention that and during the period of those activities, and because we were working remotely, we didn't miss any deadline, except for the cases which were related to the violation of the deadlines for paying court fees. All the challenges we had initially, we were able to mitigate. We established electronic document turnover between members of the team and with other departments. All cases we actually won during this difficult period. With regards to my activities as the head of department of HCJ, related to the request of the citizens, when I transferred to the HCJ, I thought that the workload would be less. I was so wrong when I was preparing to the interview. I went back to the statistics of our activities. In last years, we replied to more than 6,300 requests of citizens. That includes requests from the people's deputies, requests from the lawyers, requests from organization, from private persons. That's briefly everything about my professional experience. About importance of launching SDI. This launch, like an efficient functioning of this service, is one of the tasks of Ukraine, put by European Commission on the way to European integration. And what it will give to us: number one, it will remove workload from the members of High Council of Justice. We know that from August 2021 until 2023, the disciplinary functions was suspended. We know the amount of complaints been accumulated, and also it will strengthens independence and make swiftly consideration of disciplinary cases. And in my opinion, this is how we achieve results of having me. Number one is people, team, because a driving force of any organizations are its people, whether it's public or commercial organization. I rethought the concept of 3H, head, heart, hands. I would not see it as I would see it from the point of view what the manager should understand, what he should achieve with his unit. Head should clearly formulate long-term and short-term goals. People work efficiently if they know the aim of their work, so when they know what should be achieved. So the head kind of forms the policy of the body. Heart is to increase qualification of each team members of services. When I say qualification, it doesn't only end with professional part of competencies. This must include mental qualification, so-called emotional intellect. Everyone knows the phrase that those people who are most efficient in their work that are people who are happy. And number 3, hence, it's understanding needs and interests of every team member. To be able to to prepare some metrics, to be able to motivate people, you should understand what's important for them, what is their need. For somebody, it's financial motivation is primary. Someone should feel involved in important process. So, as the head, I must understand such needs of every my team member. Only in this case we will be an efficient organization. With regards to step number 2 is training. All of us who are ending up in public service have previous backgrounds, who are applying for the competitions. We have different backgrounds. Somebody already worked in HCJ. Someone is academician. Someone what will be important is to have introductory training session to build up the methodology of initial work with disciplinary complaints, and after everyone of inspectors, deputy and head of SDI will have certain amount of experience, we should introduce periodical events on professional improvement to make our approaches better, to hear reflections on these procedures, and I think that another important part is strategic sessions with members of HCJ. It's about exchanging experience based on their experience, to hear their point of views, learn something from them without intervention into the activities of the disciplinary inspectors. After these 3 stages, this would bring us to the result of having unified disciplinary practice and next step is transparency. We all know that society is expecting transparency from public bodies. Cabinet of Ministers introduced such initiative as transparency by default. We totally support this initiative. There is a set of, for this we regularly publish our information, and for achieving transparency, I see in following: we're having a system of open reporting with regarding conclusions of inspectors, whether case should be opened or closed, whether case will be sent for review system. So when we will start working, we will understand what filters we will have to apply.
Опублікування висновків
To publish conclusions of disciplinary inspectors after those conclusions are approved. It could be either a set of data, or it could be published in the format of the acts on the website of the High Council of Justice. I can't say which option is better now. Maybe we'll need to have a thought. Maybe it could be done in both ways. This is discussable. question to define methodology of how to develop criteria of priority for consideration of disciplinary complaints. Now they exist, but maybe it should be done additionally as internal work in this service, which would be complied with legislation. And also to inform the public on the achievements and developments of the SDI. It could be done in the format of the interim reports or as video speeches or in the format of some explanations or consultations, because first of all, the purpose of the disciplinary proceeding is not to punish judges or disciplining them, but is to prevent such offenses in future. Organizational issues.
Wrap up because it's
Slower.
No, it's already time for finishing the introductory part. Thank you.
Щодо організаційних
Regarding organizational issues, that's to assign disciplinary inspectors to different disciplinary chambers and their further rotations. That's also a discussable question, but I think that we need to discuss such issues and we need to implement such things to ensure participation of disciplinary inspectors using video conference tools. That's about time management, that's about efficiency and application of how we process disciplinary proceedings to create comfortable and safe working atmosphere for disciplinary inspectors. All of us, we understand that winter is coming. There are energetic and security problems and causes, and we need to discuss those challenges to establish a logistical process between HCJ and SDI. We need to draft the procedure for the turnover of electronic documents and paper documents. How shall we cooperate with other departments of the Secretariat as the service of discipline inspectors? That's not a separate authority or body, that's the element of the Secretariat, and that's why if there is any duplication of functions, for example, the Chancellor Office or the Department for Appeals and Requests of Citizens, if such functions are duplicated, it will lead to chaos. We need to have very clear cooperation. Each structural unit should have their own tasks and duties. It should be discussed. And the last thing, that's a very clear distribution of authorities and duties between the head of the SDI and the deputy head of the SDI. It's also employees for the organizational support for the SDI activities department, and as the head of the SDI is the deputy, de facto is the deputy head of the Secretariat of HCJ, and it will be the second deputy for, so it will be logical to define and distribute those duties appropriately.
Thank you for your preparation and detailed presentation of your vision, how this body should be built and what would be your functions and the role. And now I would like to start our session of questions from the follow-up question, because you introduced yourself, your experience, your background, and also your vision. Could you please tell us about your motivation? Why are you going for this position, for this particular position? You didn't go for the inspector, for the competition, for the inspector's position, but for the leadership position. So could you please tell us shortly what is your motivation? Sorry. So, as we have this requirement to possess English, so could you please do it in English? Thank you.
What about my motivation? I think it's clearly to understand, because nowadays I'm working with a lot of documents which comparative to disciplinary function. Why I didn't didn't apply my documents for disciplinary inspector. I'm a head of department, so my motivation is going upstairs, not downshifting. So each person want to be in more suitable and interesting place. Wanna he trying to improve his skills. He trying to find new challenges. So this is my personal motivation in this concourse.
Thank you. So basically, you are talking about the growth in your career path and going for this managerial position that reflect more your previous and current experience. Okay, thank you. So my next question would be related to again your motivation, and you are going for this particular service, which is new service and some new functions with some follow-up on disciplinary liability system as it is. How would you evaluate your level of knowledge and understanding of the disciplinary liability system and processes and practice?
Thank you for your question. My understanding of disciplinary practice is based on my experience in the High Council of Justice. I understand that your question maybe is related to the scoring which I've got for at the practical assignment stage. Yeah, I understand that the number of points that I've got is a low one. I watched so after the stage, I already watched your interview dedicated to the specific part of the competition. I don't know why, but I expected that the situational task would be more for managerial position, and questions would be more of managerial nature. Of course, it doesn't justify the scoring which I've got, and I'm so upset that I've got such scoring. But I think that all 7 candidates which reached that stage, all of them are strong candidates which have relevant experience, which will allow them to work the position of inspector, deputy head, and head. At my daily routine work, presently, most often we face with disagreements on rulings of disciplinary chambers and HTJ members. We try to provide people with explanations. What should be done? If it was purely on the formal conditions, for example, the ruling to leave it without consideration, or what rulings cannot be challenged, what drawbacks should be improved, or that's the issue of practice. So the whole Secretariat of the High Council of Justice, starting with the Chancellor Office and ending with the press service, they are full of different disciplinary processes. They understand this process itself. Regarding the situational task, maybe I've got it wrong. So what is your vision? How we shall give a reply? Because to my opinion, my replies were quite correct from my perspective. Maybe methodologically I've made some mistakes. Yeah, I admit it.
As you admit, and the result of this practical task shows that maybe this deep understanding of this disciplinary liability system and all the practices and procedures is not maybe your strongest part. So, but what would be your strongest qualities that you would say make you one of the best candidates for this position? What is your strongest qualities?
You know, before my work at the HCJ, I had not realized what the collegial body is. And now I would like to mention that it's not that easy to work at such collegial body because each HCJ member is a unique one. All of them have their own perspectives. The structure is so widespread, so understanding of internal processes is my strong side. That's for sure, 100%. I understand the structure, and my vision usually aligns with the vision of the body, and I know how to organize. I know for sure how the service of disciplinary inspectors should start working. I know for sure how to establish these communication processes, and this is one of the crucial aspects. I know for sure how disciplinary inspectors shall participate, in which way, in which, what are different options of their participation. And I think this is my strongest side.
Indicated among those preconditions and reasons why this service has been established and will be created and start working is the aim to strengthen independence and effectiveness of disciplinary proceedings. How it should be, will it be done in this service, and what is the difference between current situation and current system of disciplinary liability? What makes you say that, well, it will strengthen these aspects of disciplinary system? Thank you.
First of all, it depends on the comprehensive nature of consideration of complaints. So it's the newly established body of primary review. This service prepares documents, then chambers consider documents, and involvement of such a new body. No, I don't say that for now the consideration of complaints is not independent or is not comprehensive, but for the external observer, that's 100% a plus, a positive thing, because he or she could see that such person who have passed such competition process reviews the document, submits this document to chambers as a respected people, members of the HCJ. They consider those documents and review them. So that's the issue of structure and of different perspectives on one and the same disciplinary complaints. That's from this perspective, then yes, indeed, such consideration of complaints will be more objective. But again, at the same time, at the first place, I put the decrease of the workload for the HCJ members.
To decreasing the workload of members of the High Council of Justice, of course, the increase in the number of their assistants and current structure could be the solution, don't you think?
Maybe, but the law is the law. So we have the legislative procedure. We have the process of agreeing our perspectives with international partners has been passed, has been done. The decision was made by the leadership of the country to implement specifically such approach. As far as I remember, when there was an idea to establish a service, there were different ideas, these different alternatives. But now we are at this stage. And to say now that another option would have been better, I'm not ready to say it like this. Because, to make such conclusions, we need at least to see, to observe during some period of time how the service works. Regarding the decrease of the workload, I would like to underline that the disciplinary function is not the only function of the High Council of Justice. But for now, it takes the most of the efforts, the most of the time. That's how.
I would also like to ask you about your managerial experience and in human resources management or management of teams. So what is the largest team that you managed or led?
The largest, maybe it was at the enterprise where I was a founder of that enterprise. So different times the number was different. The highest number was 40 people. Now under my subordination there are 14 people. In state judicial administration I had 6 people under my subordination.
In your presentation, and you presented your concept as head, heart, and hands, and all of these elements of this concept are related to this internal management, people, and like strategy, then qualification, trainings of people, and also this individual approach. What about the part of the role of the head of this service regarding the external relationships and communication with stakeholders, a relationship with the High Council of Justice? What would be your understanding of the role and maybe the boundaries in this regard? What is the framework of this relationship?
Thank you for your question. Yes, indeed, when I presented this concept, I mentioned specifically, I was focused on the team of discipline inspectors, because this is the heart of all the activities where I would like to be involved. Regarding the borders, first of all, inspectors are independent, and their activities at the role of an inspector, that's already the border, that's already the red line which cannot be crossed. You can, use reflections, consultations, without going into details of complaints and naming complainants. That's yes. Regarding cooperation with the High Council of Justice, so the activities of the service are not limited exclusively to internal activities. Why is it so? Because without correct communication between the head of the service with the secretariat of the HCJ, without having well-established processes of exchange of documents, data, without some meetings, ordinary meetings, the service is not going to work as it is. We cannot, as I mentioned before, we cannot duplicate functions of other units of the HCJ. That's why we need to have communication with them, and that's definitely the responsibility of the head of the service to establish this exchange of information, of data. Maybe we also understand that a part of the electronic document turnover, which could be ensured by the software available for the HCJ, also there are so many different paper complaints. Also, it should be arranged in the logistical aspects. So if there is no joint understanding and joint concept how to exchange those documents, we will not have this primary exchange of documents and processing of documents.
Questions, but I would like to give an opportunity to my colleagues to ask questions. So, Julia, the floor is yours if you wish.
Good afternoon. I have the following question to you. Tell me, please, let's imagine that the service of discipline inspectors has already been established. 24 inspectors, and you need to manage the process and to manage those inspectors which are under your subordination. Let's imagine that among those inspectors we have those who worked before as judge assistants, as apparatus employees, attorneys, scholars with huge experience, those having PhD and other academic degrees. How you are going to build this internal communication within the service of discipline inspectors? That's the first question.
And like follow-up question, if there will be certain kind of competition between disciplinary inspectors, so any disciplinary inspector between him and you, what will be your actions in such situations? Thank you for the question. Yes, among inspectors there are a lot of academicians and even those who taught me in the university. Conflicts at the workplace can be solved, yes, by hearing every party. When I was studying at the mediators course, we did like focus sessions. Here we need to understand the need of inspector and the other party. We need to ask clear questions. Most of conflicts can be resolved by talking, having a thorough talk. Competition between inspectors, I don't really much see the reasons for that, because they are independent one from each other with regards to the results of their work. So like we will, like every case is a unique one, but like my approach would be to hear the everybody's opinion. Now under my supervision, we are not like a family, but we very like we're moving into that way. If anyone has a problem, they can they call me even at night and just ask my opinion. I'm always trying to be open to my subordinates to hear what worries them. If like you can track issue on its initial stage, it doesn't builds up. If thank you. If you will be appointed as a head of SDI, in what manner you will be able to achieve unity of disciplinary practice? It's not we can't say it will be my work. We talk about constant regular trainings that will correct these practices. In like unity is built up with time, with experience and time. Stage one, of course, it will be it will be tries and mistakes. Yeah, only those who don't work don't make mistakes. Yes, so like so trial and error approach, that this stage we should pass to build up the unified practice. Here it's not only about our internal cooperation between the inspectors. This is cooperation with chambers. So this unity will build up there. How you see your cooperation with the chambers as the head? If it's like this cooperation is an administrative part of work, so we have to assign inspectors to the chambers. We have to think about how we rotate them, so whether we will have opportunity to do remote video participation. So like if inspector has can be present at the session remotely, because if he has only like one person on that session, he will not lose time by traveling there and out. If the so and if head of SDI will also be doing functions of disciplinary inspector, I will also be communicating with chambers as disciplinary inspector. In your opinion, head of SDI, should he consider disciplinary cases? Currently, it's not provisioned, but if there will be such provision, yes, he should do that. I have no negative or positive opinion about this function as a manager. I cannot like say that I totally agree or disagree with this issue. I see this option as normal. it's not about it's more about workload of the head of SDI that should be established. Greetings. In your presentation, you said that after launch of SDI, there will be a decrease in the workload on members of HCJ. How you see this decrease? Whether indeed that will be a real decrease in workload? This it will happen due to the fact that initial assessment of the materials will be done by the service. Of course, secondary and during chamber sessions, the members of HCJ will study those cases. But inspector prepares drafts of decisions. I wouldn't say that it will remove like 30% of the workload of HCJ members, but like still it will be some release. I'm not saying that even like we will be able to give 100 or even 30% of relief of workload, but this will so actual decrease won't be happening. Yes, it will be happening, but not to that much extent as many people might think about that. In your presentation, you said that you see necessity in having strategic sessions with the members of HCJ. What will be the aim of those strategic sessions, and in what format you see how them to be conducted? We talk about meetings of HCJ members with disciplinary inspectors. It's not only with them. Maybe involving some organizations. It's about exchanging experience. It's about discussing a problematic issue, something like very persistent issue. It's not about talking about some particular case. You mentioned strategic sessions with members of HCJ. This is what was mentioned in your presentation. I want to understand the goal of these strategic sessions. Exchange of experience of members of HCJ with disciplinary inspectors. Yes, because HCJ members already have experience in activities, but this service is independent. Of course, it's not about particular cases. If we don't get tied to any particular case, there is the independence is not perishing. You said that you will establish communication with whom and in which way, and what your first steps with secretariat of HCJ, as SDI should cooperate with secretariat of HCJ. I already mentioned that. The chancellery, the document workflow, back office, press service, they will work with SDI, publicizing information, putting information of the website. I'm sure that SDI doesn't need separate website. We can have a section on the HCJ. So activities of this unit as a part of secretariat of HCJ. You said about the publicizing activities, decisions of HCJ of chambers. No, service will not be publishing. This is what a press service of HCJ will do. Again, I'm against duplicating functions within the secretariat and within a function between SDI and HCJ. And the last question, your low grade on practical task explained by the fact that you prepared to the practical task as a head. You thought this task will be related only to the functions of the head. What did you mean by that? What kind of written practical task you expected? I was analyzing other competitions, for example, competition for the head of an ACP, NABU, and I looked at situational practical tasks that were said that maybe that was put me aside, but these were like more questions of professional on the part of on the functions of the manager. If what's your action if somebody come to with you with this situation, or if you face situation of corruption in your body, like that's way that kind of questions I was expecting. Good day. I have only one question to the candidate, which I like, but due to constraint of time, I will ask only one. In your motivational letter, when you mentioned priorities of activities of SDI, you said about introduction of European standards into the Institute of Disciplinary Liability of Judges. Please tell us what particular standards you meant, what you would like to, you expect to be implemented, that you want to be introduced in. Thank you for your question. Here I meant, first of all, trainings with international partners, learning the practice of human rights courts, and like learning, so they're more or less same, but there are some something to some differences. I'm not ready to practically say what exactly, but in any case, I'm not sure that cooperation with international organizations and partners will be a plus for the service.
As a follow-up to my colleague's question, how familiar do you think you are with judicial ethics?
Recently, I studied international literature on integrity, on ethics. I can't say that at this stage I am a super expert on that matter, but knowledge that I already have, I think they're enough for me at this stage. There are a lot of interesting materials that I still want to study, but currently I don't have access to them. Now I made a request to the European Library in the Institute of Blank. They have access to certain materials from different institute, and I'm looking for replies from them on the works that I want to read.
National resources, what Ukrainian resources have you reviewed or studied or are familiar with respect to judicial ethics?
It's Judge Ethics Code. I know that now a set of comments is prepared to this code. Scientific articles. Currently, I am a postgraduate student, and so I read a lot. Bangalore principles as a basis. And recommendations of the CRES.
In what field and what are you studying?
It's Cathedra of Theory of State and Law, its legality of legislation acts, practice, and theory of. I When I was working in state judicial administration, I faced such notions like about the issue of quantitation of legislation acts. Most of the cases were related to decrease of judicial remuneration, and like the law of state budget was in contradiction with the law on judiciary. So I will not get deep into that, but and before I was studying at postgraduate course back in 2015. When I was studying in the institute, my idea was to go into prosecutor's office, and my first scientific work that I didn't finish was prosecutor's oversight over the criminal investigations cases, but due to family situation back then, I decided to quit my postgraduate study back then.
Have an opinion about whether the head would or should investigate cases himself. What do you see as the advantages and disadvantages of the head of the service having a caseload, maybe a small caseload, of cases to investigate himself?
Дякую за запитання. Дійсно,
Thank you for the question. Yes, there are pros and cons for the head and for the service. The contrast that I see is the only one. That's the increased workload on the head of SDI. We are not finally understanding the scope of administrative workload that will be put on the head. I don't see anything bad in the situation that when head of SDI will be setting example to its service, considers cases. It's not a leader who is like staying on the top and pushing people to go ahead, but this will be like lead by example case. Like this is my understanding of this.
Discussing the purpose and goals of the service, you said that it's not to discipline judges, but to prevent violations by judges. Could you explain what you mean by that?
так.
Prevention of disciplinary offenses is important, of great importance, but we should understand how we will implement this prevention. Every disciplinary case is unique in its own way, and here we should understand whether it was intentional, whether it was mistake did for out of good intentions. Like I would not say it's a constant of clarifications, for example, like ombudsmen are doing, because those clarifications, they're purely recommendatory without interfering with independence of judges, but like something like publicizing. So like most popular mistakes of the judge, how to avoid them. Maybe this will be some kind of preventional tool to decrease number of disciplinary offenses. Maybe it's a naive point of view, but that's how I see it.
Criminal justice system, there are two goals of imposing a sanction against a defendant, a criminal defendant. One is punishment for the act, and the second is deterrence so that other people don't commit that same crime. How do you see that with regard to this judicial discipline system? Do you think that there is a punitive function at all, or is it merely to deter other judges from engaging in ethical violations?
Thank you for your question. I'm sure that we cannot have exclusively only one of them. Looking, it depends on the station again. To my opinion, prevention is extremely important at any sector, not only the judicial sector. How to develop the draft concept of such prevention options, I'm not ready to tell you right now. I have some vision, but maybe that's not very well established vision to share it right now with you. Yeah, the punishment part shall be, if a disciplinary offense is committed, in any case there should be the punishment. Even more to say, such blatant cases which are right now known, they happen now, they also could work as a prevention for other judges, because other judges know for sure how it happened and under which conditions it happened. And maybe some kind of, if the case becomes a high profile case and it's published and covered in mass media, then people start thinking whether I'm doing it in the right way. So that's somehow like this. So that's how the word is spread, and everyone could reflect on this topic on themselves or together with their colleagues.
Iaku, I have more questions, but in the interest of time, I will defer to my colleague, Mr.
Thank you. Good morning.
Good morning.
My first question relates to your motivation letter. One of the points on the list of issues which you mentioned as priority areas for you as a possible head of the service, you mentioned functional independence of the service of disciplinary inspectors from the High Council of Justice and other public authorities. What do you mean by that?
I mean the following. That's what envisaged directly in the law, that the inspector at its role when considers the disciplinary case is independent. That's what I meant, that we shall understand that the manager cannot intervene, supervisor cannot intervene in the activities of a disciplinary inspector, saying that it's wrong here, please change it. That's upon discretion of a disciplinary inspector. That's the same as if a judge comes into the room of another judge saying, you did it wrong with that substantial part of the case. That's in order to decrease the risk of intervention into working activities of a disciplinary inspector when he or she considers a disciplinary complaint. Also, as far as I know, right now, the service has not yet started functioning, but discussions are already on the table regarding the future of the service, because there are already some hints in terms of establishment of the service as the primary source of the first instance. I can't comment upon it right now.
My follow-up question is this: if you, as the head, strongly disagree with the way how the inspector proceeds in a specific case, and at the same time he is independent and you cannot intervene. What would you do?
First of all, if an inspector makes some mistakes or chooses the wrong path, here the chamber should intervene. The chamber which actually will consider his conclusions. So here, because the inspector submits documents for the chamber consideration, the chamber has the right to return documents and conclusions for improvement. And such one of the performance indicators could be the systematic nature of such returns, whether documents are regularly returned for further improvement. That's why during my presentation I mentioned that such things should be covered, should be published.
Звісно, я не можу.
Of course, I cannot, approach the inspector saying, please correct it. That's wrong, definitely.
And what if this will be a case which repeats itself over and over and over again? What would you do?
Again, at the end of each year, we have an assessment. This assessment is applied both for inspector, deputy head, and the head. And each year, at the end of the year, we are able to assess their activities specifically based on such preconditions, on such gaps, such mistakes made, such systematic nature. So here we can assess activities of an inspector.
Thank you. My second question is following up of my colleague regarding the EU standards in liability of judges. Do you know what are the European standards determining liability, either disciplinary or criminal, for judges' decision in a case?
Specifically regarding decisions, yeah? As far as I know, in major part of the EU member states, they stick to the position that a judge cannot be brought to responsibility for their decisions a part of a disciplinary offense commitment. That's also implemented in our legislation and reflected in the element of independence. Yes, indeed, there is such practice of the European Court on Human Rights on different cases. Those cases which I familiarized myself with were related either to behavior of a judge or violation of the rights of procedural parties, but it was not related specifically to the decisions of a judge.
So, if I understood correctly, you say that only via disciplinary measures judge can be held liable for a decision in EU member states. Did I get it right? That judge can be held liable for the decision, or are you saying that he cannot be liable for specifically for a decision issued in a case, which, for example, is totally contradicting the law or is based on made-up evidence?
Again, if evidences are doctored, this is a separate criminal offense. For now, I cannot say for sure regarding different approaches. I can tell you about my perspective on independence. Our legislation clearly says that a judge cannot be brought to responsibility for the decisions made by him or her, a part of the commitment or a part of the commitment of the offense or of a crime or of a disciplinary offense. That's why.
Question. So what are the conditions for bringing judge liable in disciplinary process for decision? Under what circumstances it can happen?
That's clearly defined set of conditions. Now we are speaking about disciplinary function, disciplinary responsibility.
The
Criminal.
European standards in bringing judges or making judges responsible for their decisions.
In criminal procedure.
Or disciplinary. You mentioned that in your legislation, judge can only be held liable via disciplinary action. And my question is, under what circumstances this can be the case in case of judge's decision?
A judge can be brought to criminal responsibility if the criminal offenses are committed envisaged by the Criminal Code of Ukraine. If we speak about Ukraine, earlier in our legislation, there was such a sanction regarding unlawful decision of a judge. If I'm not mistaken, it was considered as against constitution provisions, and that's why now we don't have such provision in the law. That's my answer.
And my last question is conceptual. Do you think that integrity, judicial integrity, is a binary category? You either have it or don't, or it's not binary and you can somehow scale it. You can have certain amount of integrity. But where do you stand on this crossroad?
That's a very discussable question. I think that each of persons, each of people perceives the issue of integrity in an individual manner. For me, the integrity is my principles, moral features and ethical principles which do not change under the pressure of time.
Question. I didn't hear the answer whether you think it's a binary category, you either have it or not, or you can scale integrity by certain amounts of it. And you still have integrity even if it is not 100%.
Your question is so not that easy. I think that in order to measure such integrity, we need to study, to review a huge number of different factors, maybe motivation of a person. If we consider a specific case with specific actions there, or acts committed there, we need to study this case from all perspectives as much as possible to understand whether it's a mistake, whether it was done intentionally or not. I think that the integrity does not appear from nothing and does not go away to nowhere. It either exists or it does not exist. Whether a person betrays their own principles, you can see it during specific periods of time, not in a specific moment, but during specific periods of time. But if we have some more entry data for reviewing this issue, for answering this question, maybe I will be able to improve it, to explain better to you. But that's how I see right now the issue of integrity.
For now.
Thank you. So I think we can finish this part of our questions. And now I would like to ask several questions about related to integrity. And in principle, you provided us with answers and additional documents and proofs to our questions regarding your property integrity and some other aspects, but I would like to raise still some questions. So first of all, about your the funds, the sources of funds for the acquisition of the apartment in Kiev. You provided explanations and tax declarations, asset declarations for the period from 2010 till 2021, and you proved that you had sufficient funds for the acquisition, and it is supported by the paid taxes for this amount of funds. Just one question. You provided, as I said, declarations for the period from 2010 till 2021, and in this period you didn't provide declarations for the 2015, 16 and 17, and also 2020. What was the reason that these years are missing from declarations? Could you tell us, please?
Дякую за
Thank you for your question. Maybe it was related to the fact that at that time I was employed. So I didn't see that it was needed, because at that time there were some interruptions at my working period. Anyway, you know, there was no intention from my side to hide something from the selection commission. Maybe I missed something to add. Maybe you have seen how many annexes and attachments I've provided you with. I provided you with all certificates on payment of taxes, on income for my whole professional life. That's why definitely I didn't have any intention to hide anything from the selection commission. In that case, I would not have provided you with anything at all.
Some questions about the acquisition of a number of cars during your trips to Georgia, and there were, if I'm not mistaken, 5 cars acquired. One of them is still in your ownership, and 4 of them are sold, right?
ні.
No, all of them are sold. The last one was brought to me for my personal usage, to use it as a means of transportation by me. I don't remember when it was specifically sold, whether in 2020 or 2021. I don't remember the year. It was sold through the specific commissioning cars agency located at the Vita settlement. Other cars were purchased using the funds of my acquaintances. And again, I reached out to the main service center of the Ministry of Internal Affairs, asking them to give me the amounts of the agreements when the cars were sold. They told me the documents were stored for 3 years. They didn't provide me with this information. I recall in my memories that yes, indeed, these were such sums, more or less formal sums, because it was not a sale agreement, but more of re-registration.
Ask you about this declarations. Were some discrepancies in declaring the joint ownership, also the right to use the property, because you explained that some of them were because of some guidance from state bodies, and also some discrepancies that should be fixed. And now I would like to come to the question about the website of the enterprise that was your family business, and you were working in this enterprise from
9.
2009, yes. And at that period, the website was developed and launched, and the website was and still is in Russian, and no Ukrainian version, and also the very technologies also of the Russian origin. Could you please tell us about the circumstances and all those things that are related to this launch of this website and your role in this?
Thank you for your question. The website was developed back in 2008. what is it, LP Motor? Actually, I found out based on your questions. I'm not very good, I'm not very keen at the IT sector. Back in 2008, when this enterprise has been established, as far as I understand, the choice of the developer was made on the price and quality and the beneficial commercial offer and quality. I don't know who did it because I just don't know. Definitely the website was there was a Ukrainian version of the website when the enterprise was functioning. When today, not today, but when I've got those questions related to the website, so the enterprise was sold quite long time ago. Neither me nor any family members, for now, we have no relation to this business. I have studied this issue, so the website stopped its indexing back in 2019. Someone purchased the domain name, fully copy-pasted our activities. Maybe it was done by some of our franchise partners. I don't know. I don't know for sure. I looked that the office is located in Kiev, somewhere at the Bogdana Khmelnytskого street. I don't know what this office is. As far as I remember, if I'm not mistaken, a private entrepreneur purchased the domain name, but I don't know who this person is. Going back to your ethical question, for now, yes, indeed, such activities are non-ethical, but back in 2008, there were no such things. There were different relations in the society. There were no such requirements. Everything was different at all. No one thought whether it was ethical or not, but that it was on 3 languages available, that's for sure. It was Ukrainian, Russian, and English. As we cooperated with other countries. We implemented the concept of master franchise. Definitely, it was not only one language version.
Your additional comments. And now I would like to ask some last questions regarding your trips abroad. So first, we had some questions about your trips to Belarus during 2018-2019, and you explained and provided evidences that you were going for the sports competition of your son, and you provided some awards from these competitions. So this question and this part is closed. We are satisfied with your explanations. The other issue is your trip abroad during already the martial law in force. It was from 27th of December 2022 till the 2nd of January 2023. During the period of celebrations of Christmas and New Year's, and you provided explanation that you were participating in some project of the State Migration Service, and you were going for kind of testing and some opportunities for opening the branch of this like new product, which is called Document. Could you please tell us about this trip and this exercise?
As I mentioned in my explanations, the main goal was at the beginning of war. You might recollect the company DP state company Document. They started issuing passports from mobile branches. There were a number of situations because this company had, I wouldn't say it's an authority. This was not a consulate body, and to be allowed to issue those documents. And in one of the meetings maybe in September of 22, I was on one of the events, and I met with first deputy of Minister of Internal Affairs. So we knew each other before, and he told me about this conflict and such situation, and as I mentioned, that I said that I know officer in Czech Republic who is involved in human traffic issues, and this includes issuing official documents, and I offered to introduce them and discuss those issues. I was asked to contact him on my own and to go and meet him. I understood that as a public officers, I wouldn't be able to do it during work time, so that's why I took a holiday. From outside observer, it looks like that I went abroad during winter holidays, but it's all confirmed by the opening opening state company, and I gave complete list of contact of persons who were witnessing to those activities. And yes, yeah, it happened to be during holiday season, and when my wife learned that I'm going there, she said that she can come along, like for state maybe for to spend these days together. But like the working issue, we solved it. We implemented the project. We consulted with the lawyers in Prague and with the representative of law enforcement agencies, and now that project is working.
Question,
Yeah.
and not just because you were a public servant and at that time you were already working at the High Council of Justice, right?
Ні.
In the Secretariat?
No.
But you didn't went for a business trip. It was like your private trip, but you had this relationship with migration service. But apart from this, also this period, very particular period when, in fact, in Europe, not many people are working. Just 2 days or 3 days after Christmas, and that's the celebration. So it is quite difficult to do business on these days. So it is raising some doubts about the very aim of this trip and the the context.
Я розумію. Щодо того,
With regards to my status of public officer, I also want to mention that at that time, for the category B of public servants, there was no restriction to go abroad. With regards to Christmas period, it was difficult, very difficult to persuade them to work at least 2 days. But we had this urgency of opening those projects. So like but we had to implement that project. We had task from the State Migration Service and the Service of Ministry of Internal Affairs. That's so. I don't know if you had contacted persons whom I mentioned in my explanations. So, but we had that meeting. We have a result. I'm proud of that result. In the letter on allowing me to go abroad, I was allowed to stay there for 10 days. I returned on January 2nd. I stayed there for so I didn't. It was not like a road trip or for shopping. So.
Good.
Participate in such a competition, in such a procedure, in such a difficult times. I wish to all of you a peaceful skies, and I'm more than sure that you will make correct decisions. I wish you all the best. It was a pleasure to talk to you.
And coming today and sharing with us your insights, and our decision on the winners will be announced tomorrow, and we wish you the best of luck. Thank you.
Yeah.
Добрий ранок. Good morning. So we are continuing our interviews with the candidates for the position of the head of disciplinary inspector service. And now we will conduct the interview with Pani Alexandra Lubarec. And first of all, let me introduce our commission. You already participated in the competition, so you know the commission, but just to remind you that today the commission is its entire composition. I'm Reda Moliene, the chair of the commission. Commission members are as follows: Yulia Bokova, Olena Kovbi, Olha Popikova, John Ehrlich, and Pavel Zelinchik. The interview will last for approximately 1 hour. Usually we extend the interview up to 10 or 15 minutes. It depends. And first of all, you will be given the floor to present your vision and your motivation up till 10 minutes, and then we will have the session of questions. First of all, we will be asking you the questions regarding your professional competence and managerial experience, and also the second part will be dedicated to integrity aspects. And at the end, you will have several minutes for your final comments. As it was in previous interview, this interview is also broadcasted, so if you have any information which falls under restriction for its public disclosure according to the martial law, please inform the Commission accordingly if we will touch these aspects during the competition. So, would you have any requests regarding the composition of the Commission? No requests. So then we could start our interview and discussion, and now there are like up to 10 minutes for you to present your vision and your understanding how you would establish this service. So the floor is yours, Pani Alexandra, please.
Доброго дня.
Good day, esteemed members of the committee. I'm very grateful for opportunity to participate in this competition. I'm very glad that I'm at this stage and I have opportunity to present my vision on how service of disciplinary inspectors should be developed. The main goal, which is provisioned by the law on High Council of Justice, is implementation of the powers of the High Council of Justice to conduct disciplinary proceedings against judges. In my opinion, this is the only task and the main task of this service, and it means that service timely and at high quality level process disciplinary complaints, taking into account the priority of their consideration. Priorities are defined by the law in details and detailed in the rules of procedure of the HCJ, and we should adhere to that provisions. Number 2 is preparation of well-reasoned and substantiated conclusions, because based on that, disciplinary chambers will take their decisions and members of HCJ will make their decisions. And also, the main goal is to develop an unified disciplinary practice that will be adhered later throughout the years of functioning of this service. With regards to principles and values of this service, first of all, it's independence. It's not directly provisioned neither in law nor in the rule of procedure at the moment, but in my opinion, it's a presumed value by considering the procedure that we are now going through and considering expectation from this service. And number 2 is competence. I always put as a priority for myself competence, because to be able duly perform tasks that will be empowered to the service, you should understand, you should be competent in your activities and integrity. One of the major, if not the most important principles for as of today, because requirement of integrity is not put only to the service of disciplinary inspectors as a newly established body, but to all public service of Ukraine, and this is something to be taken into account and here too. And adherence to professional ethics, as law defines, law on High Council of Justice, disciplinary inspectors are extended with general requirements to the public officers and also requirements provisioned by the Code of Judicial Ethics. So for inspectors, it's a double burden of responsibility, and in their activities, of course, inspectors should adhere to the professional ethics justice. All decisions to be taken then and made by the inspectors, they should be based on the requirements of the law, and they should be just at the same time. As it was many times said, and I agree with the opinion that service should not be a punishing body. It should be a body that will impartially and in a just way, according to the law, will give assessment to the actions of the judges. And efficiency. In its activities, service should show results of its work, and we should define objective criteria that will allow to both to professional community and to general public to assess the efficiency of this service, of the functioning of this service. Principle of transparency and openness, as well as principle of integrity, they also go hand in hand, because service is part of a public body. It should be accountable to general public, first of all, and the requirement of having this service was based, among other things, on requirements to improve transparency and openness of judicial system and so its activities should be transparent. And how we achieve it by, I agree that that we should make possible to publicize conclusions for the general observers to understand why a particular decision was made. And priority tasks. As a candidate to this position, I see two immediate blocks of tasks that should be implemented in parallel. Number one is strategic tasks. First of all is to have in place regulation SDI, because it will be the major documents that will guide the activities of inspectors, because legislation doesn't provision any specific criteria to be put in this regulation. But in my opinion, this regulation should stipulate independence of inspectors. Number two is a basic principle for any procedure is opportunity for inspectors to announce recusal or self-recusal in any case, because quite a few candidates for the position of the inspectors, they were practicing judges or practicing assistants to judges. They had cases in their previous professional activities that might make them biased in considering any case. And number 3 is clear criteria for disciplinary responsibility of inspectors, because both inspectors and outside observers should understand what actions of inspectors should goes to their liability of the inspector, because at the initial stage we should of this work of service there will be mistake. We cannot say that from the day one service will work without mistakes. So we should clearly define what actions will cause liability in order to avoid them in future.
З Вищої ради про
Then the second thing is that to establish rapport and cooperation with HCJ. The service as a separate unit, of course, is independent, but it cooperates with the High Council of Justice, starting with receipt of documents by the service and then submitting those documents for consideration to the HCJ. We shall definitely be aware of the algorithm of such cooperation, and as I have mentioned already before, during such working process there could be raised some comments or concerns which do not impact on the final results, but maybe they can strengthen argumentation on some decisions, and we shall understand, we shall recognize how such comments provided by the HCJ members can be taken by us into consideration, and how should it be done. Then, to evaluate evaluation of the activities. Disciplinary inspectors are civil servants. The law on civil service envisages that by the end of each year, their activities should be evaluated according to the law on the civil service. At the same time, the specificity of activities of the service tells us that activities of disciplinary inspectors cannot be assessed according to the current law. That's why we need to develop clear criteria in order to evaluate activities of each inspector individually and of the whole service at large. And for sure, the office, I mean the supporting staff that should ensure functioning of the service. We shall define their functions, what they are going to do, and I think that already now the procedure shall be started, shall be launched, in order to understand what staff we need there and to define for ourselves who is going to work at those positions and launch the selection process. Technical tasks, as I have mentioned already, those tasks should go in parallel with first strategic tasks. First of all, logistics. How we are going to receive complaints, literally. So, for example, once per day or several times per day, in the morning and the evening. So, how we transfer them? Do we have some lists, registers, or any other procedures? Correspondence, the same as the service is going to be located as a separate premises. We shall also be aware of how we are going to receive and send correspondence. The second important thing is that to register electronic digital signatures and have access to the registers. I'm not going to develop on the topic of electronic digital signatures because for now this is a basic requirement, and each inspector should have their own digital signature as their position of inspector, not as their position of just a person, a physical person, but as an inspector. The law defines that the service has direct, full access to state registers and databases. It's definite that each inspector should get access to the unified register of court decisions. That's a basic requirement. Then we need to define what are the registers are needed for us, because I think that we don't need access to full registers. And then when we define the need for access to other registers, to ensure such access for all discipline inspectors. Automatization of the processes. Again, considering that inspectors are going to work at a separate premises, we need to simplify as much as possible the process of receiving and sending different inquiries for disciplinary inspectors to use as much as possible different electronic tools. Again, to shorten the time, to reduce the timing, we need to work on different templates for requests or other documents, maybe for the draft rulings and so on, with key purpose to automate and simplify their work. I think that the High Council of Justice receives complaints which are quite standard ones. For example, complaints on the duration of the period of consideration of cases. Usually, such complaints are not difficult, and there is already developed, established algorithm how to consider those cases. I don't think that there is any need to change it. And in order to, to boost the process of consideration for discipline inspectors, we can develop pre-established algorithms. So what should be done? So what should be the order of steps? Also, I think that access to information and analytical resources is important. That's I'm speaking about such database as precedent and so on. Such database accumulates all case law. They have very convenient search tools, including the case law of the Supreme Court and so on. It will help to simplify their work. Or Liga tool, that's a very popular resource which accumulates a legislation database. It's convenient for usage, and I think that it will be useful and will significantly simplify working functions of inspectors. Speaking about expected results of SDI activities. So first of all, establishment of this service is caused by international commitments of Ukraine, in particular due to the accession plan to the European Union, and the Ukraine facility plan envisages for now that by the end of 2025 the service shall consider 20% of cases which were non-considered as at the end of 2023.
Interrupt. Could you please finalize
yes.
in 2 minutes or so? Thank you very much.
As I see it, results of activities of SDI, I think it's досить зрозуміло.
It's quite clear. That's why I'm not going to dwell upon it. If you have any questions, I'm ready to answer them. I would like to mention that the key task which I see in front of myself at the position of the head of the service, that's to put this stable, solid foundation which will allow the service to function appropriately and independently from the external factors, such as, for example, when the High Council of Justice doesn't have its mandate because a mandate or authorities of their members is terminated, or because of any other factors. We need to ensure a solid functioning and stable functioning of the service independently from external and maybe internal factors. That's all from my side. Thank you. I'm ready to answer your questions.
For your detailed presentation, and now I would like to give the floor to our commission member, Mr. John Ehrlich, to start our session of questions. So the floor is yours, please.
Добрий день.
Доброго дня.
Thank you for being here. You may or not be aware that you had the highest score on the practical examination, so I would like to congratulate you on that.
Thank you.
And also on your becoming a finalist for disciplinary inspector. We we already have obviously a lot of information from you from your prior interview. So we're going to be focusing significantly on your role as a manager and as a leader. You provided us with a lot of information already through your PowerPoint. What I'd like to ask you is, if you're sitting at this table, what characteristics are you looking for in a leader or the head of the SDI? So what characteristics are you looking for the person in that seat? And if you could, because one of the requirements for this position is to be fluent in another language. I understand your other language is English. If you could respond to me in English, that would be appreciated.
Okay.
Thank you.
Thank you. I want to apologize in advance because I'm quite nervous now, and maybe I could make some mistakes. So, for main characteristics for the leader of this service, I see it first of all, it's competence. For me, it's very important because the leader might be professional in his field, and also if leader is competent, it provides respect from his employers, and also I think it might be responsibility. A leader should take responsibility for his actions and for not only as a human, as be in charge of the service, but also for the act of all the service in common. And he might be confident in his actions and take responsibility for actions as for himself, also for inspectors. And he might be confident, and such characteristic for me, it's also important. He must be brave, because the challenges that are now for this service demand from the leader that he might be quite strong in his decisions, and he could to stand for principles and for all activity of the service.
Thank you. You can now respond in Ukrainian if you would like. You use the word brave. What does the word brave mean to you?
For me, it means that, so first of all, that's some kind of resistance to the pressure. Secondly, you need to stand appropriately for your position, for your beliefs, because the functioning, the activities of the service envisages direct communication and standing for your own position in front of the HCJ members. HCJ members are professional judges. Among them, there are judges of Supreme Courts, attorneys, prosecutors, people with huge professional experience. You shall have the strength and bravery to stand for your own position independently. Maybe it's not correct to say, but nevertheless, I'm going to say it. In order to withstand in front of the authority of those persons, you shall be brave and strong in your actions.
You said stand for your beliefs. What are your beliefs?
Перш
First of all, I believe in justice. I'm sure that if a person commits any violation, any offense, he or she should be brought to responsibility. If a person doesn't has not committed anything, anything wrongdoing, he or she should be sure that they will not be brought to responsibility. I'm always standing for it, for independently from the pressure of external and factors or internal pressure. I also believe that you should be professional at what you are doing, at your job. And such key so to me, these beliefs are key ones, and I think that they will help me to do my job effectively, independently, whether I take the position of a disciplinary inspector or as a position of the head, if I successfully pass this competition.
Do you see yourself as having any weaknesses or shortcomings in terms of leadership abilities or qualities?
For now, I can't say that I have some kind of shortcomings that would become an obstacle for me to perform this function appropriately. But for now, also, I cannot envisage all challenges that the service would face, because my life and professional experiences tell me that if anything could happen if it doesn't contradict the law of physics, the physics rules. That's why we cannot envisage all challenges which could be raised in front of us. That's why I'm sure that I will be capable to face all challenges in appropriate manner. I rely upon the teamwork, whether I am appointed for the position of the deputy head of the service. I'm confident that I will be able to establish the adequate level of work in order to feel the support from the service and for the service to feel the support from the leadership.
As the head, do you think that the head should have her own caseload to investigate, or just have a managerial position?
я думаю,
I think that for the heads, it's important to have experience in consideration of disciplinary complaints. That's for sure. Because in order to properly manage, including to properly execute the function of support to inspectors, the head should understand what his subordinates do, and consideration of disciplinary complaints, specifically if a person appointed for the head has no experience in consideration of such cases, is extremely important. In order to have this deep understanding of the station, as one of the tasks of the service is to unify disciplinary practice, and the head of the service will lead this process from the side of the service, to my opinion. The head of the service will coordinate this whole process. That's why the head of the service should understand the nuances of that matter, and the nuances in terms of application and implementation of disciplinary procedures. That's why, yes, I think that the head should have this workload of consideration of complaints. The only fact that with consideration of the general workload, and also it's not yet clear the whole set of functions for the head. So the only issue is that the workload. Of course, definitely, the head should have less workload in comparison with inspectors. In terms of this matter of consideration of cases, and maybe it should be adapted when the service starts functioning at full.
If you are chosen, if you are appointed as the head, you will be the public-facing figure of this new service. We touched on some issues in your last interview, and I would like to explore them further. And I hope you understand the context of why I'm asking you these questions, because you will be the public figure, and you have worked with some members of HQCJ and HCJ who have made very controversial decisions or have engaged in controversial actions. And I would just like to start with asking you whether you are aware of those controversies with specific members of HQCJ and HCJ. All right?
Yes.
Okay. So I'd like to start with member Vasilenko.
Yes.
And you worked with him for about 2.5 years. Are you currently aware that member Vasilenko was considered to be opposed to judicial reform?
Я хочу зауважити.
I want to say that, of course, there is some information. Of course, some actions were made that might cause doubts from the public and third-party observers about how proper these actions were. I cannot deny this. It's a fact. As of today, I can only accept it as a fact. It's happened. Yes, I worked with that person, but in my direct activities, I never committed actions that would cast shadow on me as a specialist, as a professional, besides the fact that I worked with that person. So what I mean, I understand that I will put some burden of responsibility for this circumstance, but I want to ask to separate me as a professional from the member of the committee Vasilenko for his actions which he committed, and again, decisions that were made were not made by him personally. It was a collegial decisions or as part of the panel of the HQCJ or in plenary composition. As I mentioned, in my work I adhered to all principles, including principle of integrity, and this is confirmed by the fact, as I gave explanations when I was filing a request to law enforcement authority, when, for example, a judge of Kyiv district administrative court asked me to remove some information from his dossier. This was when I was working in HQCJ, and I went into that mechanism of actions that was provisioned by the legislation. Doesn't matter on the possible consequences for me that could arise, considering that district administrative court of Kyiv at that time, it was before the Judge Vovk's tapes. There was not that much resonance around that court, and at that time it was quite a brave step on my behalf, and I did as I believed was correct to act, and I think that there is no place for doubting in my integrity. That's my answer.
My colleague, Commissioner Papikova, is going to follow up on that Kyiv court issue that you just raised and the law enforcement request. I am not questioning your actions. what I'm trying to get at is, what is the public perception going to be if the new head of the Service of Disciplinary Inspectors worked with members like Vasilenko, worked with Ovsilenko, and worked with Shelest? Do you understand our concerns?
Я розумію ваші сумніви.
I understand your concerns. I understand that maybe in case of my appointment there will be some public resonance, but I speak for my work, and I said that you can evaluate me as a manager by the results of the work of the service. So I'm sure that with my work I will disprove any doubts that might arise.
Working as a civil servant or as support staff?
I worked with Vasilenko initially as the public officer, then as an inspector. With Ovsienko and Shelet, I worked as inspector, and later at the end of our work with Ms. Shelest, I worked as public officers. But functions that were provisioned by law and regulation, they provisioned that independently on what formally was my position in all my job descriptions, and in the law it was provisioned that my main task at that position, doesn't matter how it was called or named, it was to accomplish tasks of the member of the HCJ or HQCJ.
Tasks were, I'm asking if your position was designated as a civil servant or as support?
Support.
Support.
Yes.
Okay. Member Shelest was very controversial, was she? Was she controversial while you worked for her?
Yes. Чому я з нею працювала? Oh,
Why I worked with her? Yeah.
why I worked? No.
No, while you worked with her. Yeah. Yeah.
Можливо, уточнити запитання, я так зрозуміла.
Can we clarify the questions because we have issues with translation?
Is this, was she taking controversial actions while you worked with her?
Під час моєї
When I was working with her, there were some actions or decisions that, as I understand, were made, as I recollect, because it was a couple of years ago, that certain decisions were adopted regarding public judicial reform, or regarding certain activities of her as the member of HCJ. But as far as I can generalize and summarize this work, mostly decisions were approved not in context of my work as disciplinary inspectors, and to any organizational decisions that HCJ was adopting with regards to requests to the Supreme Court or to other bodies, or with regards to public announcements. as far as I know, inspectors, in particular in the office of Ms. Shellist, we were not related to that. We only worked with the materials that were assigned to us by automated appointment system.
Controversies in some of her decisions and some of her actions. Did you have any concerns at all about working for her or with her?
Of course, I have some concerns. It's obvious, but розумієте, тоді
You understand? At that time, I had a choice: either I work or I lose my work. I was not of the opinion. I rephrase. For myself, I thought that the work that I am doing at this position will be of much more good comparing if I resign from this work.
What's your concerns?
to her?
To her.
No.
And don't tell me the names of anyone, but did you express your concerns to anyone else?
Yes.
Were you expecting those other individuals to take actions based on her conduct?
I don't clearly understand. Can you repeat, please?
Sure. When you expressed your concerns to these other individuals, did you do that in order for them to take some action in response to her conduct?
Ті особи,
Those other persons to whom I could have expressed my concern, they had no levers to somehow influence that or rectify that.
Inferring that you did not report her conduct to people who had the leverage or the authority to do something.
для того,
To report certain information with intention of influence or to prevent certain actions, there should be a couple of factors in place. First of all, I should understand intention of doing some actions. And number two, not always, I never could have forecasting certain her actions as a member of HCJ, based like in particular on administrative actions or adopting some decisions, in order to to be honest, when I'm thinking on your question, I cannot like imagine to whom I should have reported in order to some actions to be taken, because law enforcement agencies know. I don't see or I wasn't a witness to committing certain actions that would allow me to report on them. Ethical aspects of activities, there was no need for me to report somewhere. It was generally known.
A number of other questions, but I also want to give my colleagues an opportunity to ask their questions. I want to thank you for being very responsive to my questions.
Дякую.
Thank you, Jakub.
Thank you. Could I ask the question because it is related to what you've been asking, and I would like to proceed with this, and then we could come to some other aspects of your activities.
And I think Olha also has
Yes.
a follow-up question.
So it's for us and for me, and I believe for other commission members, it's very important to understand your considerations and your like values and understanding of the context and of the situation, and not maybe responding particularly what kind of actions did you take in a particular situation, but still having the overall context, the overall picture that you had, I would call it such a bad luck to work with people who are like, one is controversial, the other again controversial. And as you say, and I believe this is an honest answer, that, well, it's not possible not to know and not to understand what is going on, because people are talking, civil society is expressing concerns. And even for external participants, I would call us as an external experts at that time, when the judicial reform, this huge judicial reform started, and there was this kind of, the hope that the situation is changing and those corruption problems will be tackled, and this judiciary is going on the right path to a more independent and accountable judicial. And there was a concern from those external participants that, well, sometimes it looks like one step forward, two steps back. And it was made by this kind of people who were in the system and who were acting against the system, and their reputation was at this time this. So I think we got even in some frustration sometimes that those efforts of people who are trying to do something, they are like I would say diminished from the side of this kind of people. And you were working with day by day. So did you have the feeling that what am I doing here, because I have knowledge, competence, I have wish to do something for this country and for judiciary? Maybe I would be better in other capacity, in other position. I don't know, maybe civil society. I'm not talking that, well, have you ever considered to leave the job? But what was your consideration about this whole situation that is going on around? You see those strange activities, strange actions, and the society. So, could you please just share with us honestly your considerations with regard to this?
Безумовно.
With no doubts, at that time, especially when this was like not one-time wave of concern. It was increasing gradually, including public disappointment, and at some stages I had some thoughts about this. I should say that to work with Miss Shellist, it was not easy. But I thought that by working in that position and completing tasks that I had, I wasn't able to influence her decisions, their decisions, but I thought that by doing honestly and the work that I'm doing, because like to quit, it's the easiest variant, yes, just to say I don't want to work here anymore, but I took that responsibility on myself, and I keep holding myself accountable for this, like taking share of this responsibility. But I thought that by continuing doing my work properly, I as a specialist will be able to make the work of body better. You know, the big body consists of small elements, and I thought that I'm this small element that ensures I do my work properly. I understand all those doubts and all this situation, but anyway, the fact of of uh, of being responsible of working there, I also bear certain kind of responsibility for something that I was not directly involved in.
Proceed, but as my colleagues, I'm sure, do have some questions, I would like to give a floor and to give an opportunity to ask. Maybe, Pavel, you would like to?
Let's do it in order. Shall Greetings, dear Alexandra. So, to follow up the topic that was already raised, tell us, please, how do you stand for your position? With arguments? With argumentation? So, I provide those arguments which I think are appropriate in each specific case. So here, at my work generally, there are not so many options how to prove my position. That's a convincing talk, discussion, with provision of appropriate arguments and with my position. Okay, but if your position does not align, for example, with the position of the HCJ member, where is there any situation when you stand it for your position? For example, the HCJ member had their position, but you managed to convince him or her, and he or she changes their position. Can you give us some examples? Yeah, there were such examples. And in major part of the cases, we reached the consensus. There was one case which I shared with you in the last interview, the rest, when the HCJ member didn't agree with my position. But again, as the inspector, I had very limited opportunities. I was not able to go higher and overcome my member and reach out to other members and say that the position of my member is not that correct one. To my opinion, at least it's not ethical. But also the decision is made by the chamber as a collective body. So if the chamber makes it a relevant decision, and chamber consists of 5 people, major part of them are judges, that means that they have made this decision. But here it's important to be aware that I did everything possible in order to withstand my position. Okay, thank you. Tell me, please, how you are going to act when, for example, at the team of the Service of Disciplinary Inspectors, there is a different standing on how to solve a problem, and this position differs from yours. Communication. Everything shall be talked out. Everything shall be discussed. That's for sure. You need to look at arguments, at pretext. You need to at legislation provisions to develop that position. And again, I don't say that my opinion is the final one and like decision of the final instance and the most correct one as what I say, so that's how it's going to be. No, for sure not. Definitely it will be a question under discussion. We will discuss, we'll have a talk. Maybe some arguments could be provided that would change my position, and I would change my position, my standing. Thank you. One more small question to you. Tell me please, did you ever need to offer some new solutions or new approaches at your work? Yes, from the organizational perspective. Again, going back to my managerial experience, I would like to mention that when I was appointed first time for the managerial position, it was at the Ministry of Agrarian Policy. I was appointed for the position. I headed the sector for interaction with the Verkhovna Rada of Ukraine. My appointment took place in very turbulent atmosphere. I was 24 years old. It's quite a young age for a managerial position. I didn't have previous experience before. I had employees of age higher than mine, and it happened that I needed to organize, to arrange the whole work from the scratch, literally from the scratch. I was told, here are your employees, here is the office where there was one table and two chairs and nothing else. So in 3 weeks, the plenary session of the Verkhovna Rada should have taken place, and we should have been already prepared for this. It means I have done and arranged everything from the scratch by myself. Given the fact that previous employees who were that role were dismissed, I didn't get any transfer of the affairs, of the causes. I just was appointed. I came my first day. I was told, that's your work. Please do it. So, de facto, I have arranged the full functioning of my sector from the very scratch, from the very beginning. If I'm not mistaken, this sector has successfully operated for 2.5 years. So everything what we have implemented, starting with communications, and again, communications was in the following, that my sector envisaged interaction with the Verkhovna Rada for Ukraine for the whole our ministry. So all the employees, all draft laws initiated by the ministry were considered, which were considered as the Verkhovna Rada. There were also 5 separate state authorities which were coordinated by the ministry. So de facto, I have arranged functioning of such important structural unit from the scratch, from the very beginning. The challenges were serious, and for me as a manager, as a head, because definitely I faced some bias, some prejudices towards myself. First of all, because of my age. Secondly, because of my lack of managerial experience, and all processes that have been arranged, they kept working even after I left that position. So yes, indeed, I had this experience of arranging the whole process from the very beginning, from zero level. Tell me please, how many subordinates were under your subordinations at Sector 4? And what were the areas of activity? Were they of the same age or not? 2 of them were of the same age, more or less, and the third was of the higher age in comparison with all of us. I don't remember specifically the age because it was 12 years ago, and I don't remember the previous experience, but everything we learned together, and we have done everything together from the very beginning. Greetings, Alexandra, and just to follow up questions of Reda and John. So my question to you, if you had not agreed with decisions of Judge Shellis, what you have done, what she told you, then what was the usage of you to the state and the judiciary system? The decisions which were made by Madam Shellis and with which I would have not agreed, they were made without my involvement at all, and my participation and involvement on that matter at all. Okay, thank you. When John asked you, your answer is that you didn't express your concerns to Madam Celeste, but at the same time, you said that you expressed those concerns to some other persons. Were those persons HTG employees or any other third persons? Some certain employees with whom I had close communication, and some other certain persons who were not HTJ employees. But again, get me right, I couldn't come to Madam Shellis and say, Svetlana Borisovna, what you're doing, I think it's wrong. I didn't think that it would have been ethical and correct based on, even from the perspective of my position. Okay, then tell me, why did you share those concerns with other persons, and was it ethical from your perspective? Just to give you an example. So the article was published. There were so many different articles in the mass media at that time. Of course, we are a team. This information is circulated, and again, this information was discussed exclusively in private communications. It's not that it was like a meeting of 10 people and we discuss all those issues. No, there were private talks, and maybe in those private talks I mentioned that from my personal perspective that decision was not completely correct. So the decision which was mentioned in that article, not obligatory, maybe some actions, not specifically decisions. Situations were different because articles were different. Do you mean actions as a person or actions of her as an HTJ member? Both. Okay, thank you. To your opinion, do you think any advantages in this competition for the position of the head, given the fact that you are an employee of the HTJ and you are an assistant to the deputy head of the HTJ? As the advantage that I can see regarding myself, that's the key advantage, that I don't need to deepen into the process because I know how the HTJ works, how the secretariat works. So to say, I don't need this additional time, which maybe would be required for other candidates in order to launch work of the service. So it's about saving the time to familiarize myself with the process and to integrate into the structure. I think that's my advantage. Okay. Don't you think that it would be a concern for another candidate if you and another candidate, you are on the final stage of this competition and your names are submitted for consideration to be nominated for by the HCJ? No, I don't think there would be any concern. Our level of competence would be on the same level. Okay, thank you, clear. Tell me, please, what does subordination mean for you? Subordination, it's about mutual relations. Subordination means when someone subordinates to another person. That's a team. It's relations in a team, which envisage some kind of the level of relations when one person subordinates to another person. And then, how do you build your relations with subordinates, with your supervisors, and with HCG members? How I'm going to build? No. How are you building them right now? So when you were the manager, so how did you build it? So you had some leadership, and now you're an assistant to HCG member. How do you build such relations? So first of all, of course, I have some subordinating relations with an HCJ member to whom I am assigned. He's my supervisor and I'm his subordinate, that's for sure. Regarding office employees or secretariat employees or employees of the Mr. Oklyanov office, we have absolutely equal relations. There are no some kind of subordination or advantage between us. We are all specialists working on different tasks. I'm sure that any relations including working relations, should be based on trust and mutual respect. These are key crucial aspects which will help to build relevant interaction or cooperation independently, whether there is peer-to-peer relation or subordinating relation. Okay, thank you. So, if such quotation relates to you, how you can comment upon it? Can have difficulties with implementation of complicated projects or working under huge pressure or workload. So it's normal. If a person faces some difficulties under conditions of the heavy workload or pressure, but the issue is how a person is going to overcome those challenges. But the fact of the presence of those challenges, I think that it's okay. It's a normal story in any work. And how we are going to solve such difficulties, depending on the situation, depending on what I can do at my level, what actions shall be taken by me in order to mitigate such situation, to correct such situation, to do everything possible from my side, to do my best, recognize which actions are not under my influence, and then based on all those factors, I shall arrange how to do that work where I face challenges.
A possibility to ask questions that are really important and for you to give your position. So we will extend our interview for maybe 20 minutes, I think, and if it's
Yes,
all
yes,
right.
okay.
Okay, and then I'm giving the floor to Oleha to ask the question.
Greetings again. You know, I relate so much to this your call, to this your striving for this notion of justice. For me, personally, as a person, as a judge, you know, this is some kind of the so crucial. So going back to the question asked by Olena to you, do you have any advantages? Are you having right now advantages at this competition, given the fact that you are an employee of the High Council of Justice? Don't you think, or maybe you think that this is not your advantage, that now, being at this competition, you're also an employee member. No, not member, sorry, employee. Yeah. It's like Freud's mistake, first typo. So, regarding your professional competences, I understand that, yeah, the Commission doesn't have any issues with that. You show the best level of scoring of the practical assignment. You have very good presentation. And indeed, I would like to be fair regarding you. And that's why we have this interview in order to understand. So regarding a part of your professional competences which are definitely the best, can we consider you for the position of the head of the service, given the experience, the working experience that you have? So we try to be fair regarding you. That's what I try to underline. And also, I wanted to ask you the following. Maybe we didn't ask you in detail regarding the situation which you mentioned in your presentation. When you addressed law enforcement authorities, can you please tell us more about that situation for us to understand what happened there and in order not to take so much time? So tell me please also one more thing. How many assistants do usually work for HDI members regarding assistants? So you worked only one of you was you were on the only one assistant, or there were other assistants? No, definitely the team. 2, 3. No, sometimes there were 4 and 5, and each of assistants was responsible for a specific area of work. So nothing has changed in comparison with nowadays. Yeah, nothing changed. Okay, thank you. And regarding your address to law enforcement authorities, as we have your explanations, we have documents, but at the same time, I think that it's somehow important. That's why we should listen to your explanations. Yeah, definitely. If Commission doesn't mind, I'm not going to name the persons. Yeah, it's mentioned. So judges' names and surnames are mentioned in my explanation. So I'm not going to mention them now. There was a situation when, as an inspector of the High Qualification Commission of Judges, I had files for review regarding qualification assessment of the judge of the District Administrative Court of Kiev. Our work was based in such a way that given the limited time for preparation of documents and files for consideration, upon agreement with the commission members, we have developed the list of issues that should be clarified. Before the start of the interview, we suggested to judges to provide their explanations and corroborating documents regarding questions that we had. The same as we are having right now, as the Commission is doing right now.
Запланованої співбесіди.
And a day before the interview to be conducted, it happened that into my office came this judge, entered this judge, and he wanted to preliminarily discuss explanations that he provided. When he entered the office, he was like nervous, close to my desk, and after some conversations, he went to register his explanations in the chancery of the commission. At that time, I was alone in the office. After judge went outside the office, left in some time near the place where he was staying, I found 2 gift certificates which were not there before. And in some time, he I don't know exactly it was before or again he gave me another number which was not listed in his profile, and he asked for communication via that number, and via Viber, not from this judge but like from different phone number, I received, I don't quote, but roughly more or less the same message. I was in your office today. I saw some information on your desk. Can you remove it? And given the context of this situation, that at that time I was communicating only one judge and nobody else, I understood that this is that particular judge, and I kind of correlated the fact of gift certificates, things that he asked me to do before the interview, and at that time I replied that I will not remove anything from the materials, and this is impossible, and I already reported this to the member of the commission, and I blocked that number. After thinking through this situation, I made a decision to report this case to the law enforcement, giving the context of what happened, and because I believed such conduct is totally unacceptable, not especially on behalf of the judge, but it relates to anyone, and that's why I decided to report law enforcement about this situation, because I thought it is a way of influencing and pressing on me as the inspector of HQCJ, and according to the legislation, position of an inspector was position with high corruption risk, and I wasn't able to ignore that fact. I reported this circumstance to Mr. Vasilenko, with whom I worked. He absolutely agreed with my mode of actions, and if he didn't agree, I wouldn't anyway report that. It's not a matter if he agreed or not. It's about me informing him about this circumstance, and because next day we had scheduled qualification evaluation session, and there was I couldn't have done anything else. What were the consequences of your report? According to legislation that was current at that time, I informed about this circumstance to the National Agency on Corruption Prevention, General Prosecutor's Office, National Police, and National Anti-Corruption Bureau. National NACP, they answered that this is not their competence, it's within the competence of NABU. Same was replied to me by Office of General Prosecutors, National Police, National Police.
We will solve this technical issue. Okay. Is it working?
Can you hear us, John? Can you hear interpreter? Is translation back? Test. Can you hear interpreter? John? Can you hear me?
Yeah.
Can you test interpreter speaking on English channel? Test. 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 Test.
Спробуй ще раз, бо Джон здається не чує. Спробуй ще раз, скажи щось.
Test. Testing English channel. Testing English channel. Pavel. Yeah. Testing English channel. Testing English channel. English channel. Testing English channel. Testing English channel.
Національна поліція.
National Police Investigation Department, they opened criminal case based on my report. I was called for interrogation as a witness, and I came to interrogation. I provided my witness statement, and after that, like I might not remember exactly what was the timeline, but then HQCJ had visit from the National Anti-Corruption Bureau. They spoke to me. They spoke to the member of the HQCJ with whom I was working, and they spoke about this case. After that, as far as I remember, National Police closed the case because by absence of criminal offense merit, and National Anti-Corruption Bureau, as I understood from their reply, they also did find reasons for continue case. Yeah.
You pointed in your not explanations, but after presentation, talking about main characteristics. Among them, you pointed very clearly that this being brave or courageous and being capable and able to oppose sometimes and to defend the position in front of the authoritative and authoritative people, sometimes superiors. It's very important. And we were talking about this your activities in the past, and as you now say that, well, sometimes quitting the job is not maybe the best option. Sometimes you have to do what you are doing. Sometimes you have to oppose if you have a position and you know the facts, etc. So let's move from the past to current situation, and maybe it's then also very important to understand if it's like more declarative statements or it is really working in current situation. So last year, and I think this year as well, I'm pretty sure that you also are aware of these concerns from the civil society. There were a number of interviews and in social media, and also some members of the High Council of Justice were expressing these concerns that according the regulation of the procedures of the High Council of Justice, it's pretty clear what are the priorities of those disciplinary cases that have to be handled first. These are severe gross violations. These are cases related to a huge public interest, high-profile cases with very important judges involved, etc. But still, somehow it was not handled as it should be according to the regulation. That was the concerns that we heard. We are not in the institution. And you are working now with the deputy head of, right? So, and you are aware of these concerns, aren't you?
Yes.
Have you ever discussed this and like expressed your also interest in what is going on, why it is going on this way, and maybe making, I'm not talking about influence, but expressing the position that, well, probably it's not okay if we are somehow not following our own regulations and principles that we are declaring for the public. Have you ever had these kind of conversations and discussions with your with the member, the deputy head of the council?
With regards to priorities of consideration of cases, of course we discussed those issues, because Mr. Lukyanov, he's also a member of disciplinary chamber, and we have complaints under consideration, and we discussed those issues not only with me personally but with our office, because except me there are two more assistants, but it was only in the context of the cases that were under our consideration of this particular member of HCJ, because of course there are high-profile cases, they should be considered, but the person responsible for considering that case is the member of HCJ to whom this case was assigned, and to influence that member of HCJ whether
issues, because
are you using it?
I'm not using here, but
testing. Well, that's why, like, we spoke about these prioritization issues. With regards to other members of HCJ, it's the responsibility of other members of HCJs, and law prohibits to influence member of HCJ on his activities, but I want to notice that from my experience, from my work experience, even if the case is of priority or a high-profile case, there are certain factors that can influence the duration of consideration of the case. Because I had this year, just for example, for general understanding, I had a case which provisioned dismissal of a judge from his positions for conducting certain offense. This case was difficult and it required significant time to study case materials. And number two, we were sending out a number of requests to which we had to receive reply. Then were clarifications requested. Not always, if the case is a high-profile case, not always you can consider it fast, because you need to collect as much comprehensive information about that case. Because sanction can provision dismissal of a judge from his position, you have maximally in detail work through the case materials, because of course this will be decision will be appealed in both to HCJ and to the Supreme Court, and to prepare case materials at quality level, that's of paramount importance. It's not to finding excuse, but yes, but just on the priority should be given to according to the legislation. But if the high priority case is considered for a long time, it means that there are objective reasons for such extended consideration. If there is no such reasons, it's a personal responsibility of the person who's in charge of that, of consideration of that case.
To balance this independence of members of the HCJ who are responsible for a particular case, and the interest of the state to have this handled in the best effective way. And now I would like to turn to the disciplinary inspector service. So as you say that the head or the deputy head of the HCJ and also the staff, of course, cannot like influence or impact or try to do some influence on the member of the HCJ working on particular case. So let's imagine you have the situation in the service that inspector has some high-profile cases, and you as a head of the service, you have some concerns from external people, from whoever. How would you do in this situation? Would you apply this principle that, well, the inspector is independent, he or she is handling the case, and I cannot make any influence on the process? Or there are some instruments or some possibilities to speak about this and to challenge and to ask and whatever. What is your opinion? It's about, you know, this discussion and more like conceptual but very important things.
Yes, of course.
If there is a situation when a disciplinary inspector will have a priority case and head me, if I get this position as a head, I will receive certain information that this case is not considered for a long time, or there are about other aspects. Of course, as I see it, I can ask inspector to report how about the progress on the case, what actions he or she did, just to inform, not without giving any instruction to do something or not to do something. And after receiving this information, I have to analyze it from the point of view whether duration of this consideration is reasonable. As I mentioned, yes, there was a request and there was no reply. It was important for the case. Maybe inspector will want to explain, maybe he or she will not want to explain. This all has to be taken into account, and after analyzing this information, if indeed there will be doubts, but you know, again, important issue to consider. I am not sure if I can definitely say this. If it is possible somehow influence inspector until he or she considers this case. If we go by analogy with current disciplinary proceedings against judges, if we receive a complaint regarding the actions of judge and cases under consideration, we cannot do that. According to legislation, there was a separate decision of the Constitutional Court about the intervention, and I have no final answers on that question. Of course, it's about collecting information about analytics, but further actions will depend. So before the inspector will finalize considering the case, only after that we will decide on what actions to do against him. If you will figure out this is intentional dragging in with the case. You have information that case was submitted, registered, it stays at his desk, you did analytics, and you see, you clearly understand, because you have experience how it's been considered, you see that it's intentional delaying of the case. Will you wait until its turn will come to so if we will see obvious signs that inspector acted intentionally is delaying case, it's a reason for a disciplinary case against inspector himself.
The back of time.
Good afternoon. My first question will be conceptual one. Do you know it?
Of course.
Which is?
No, I take a chance.
So please.
No. I listen it first. Thank you.
Okay. In your view, is integrity a binary category? You have it or don't? Or you can scale integrity and person can have several degrees of integrity. What is your position to this question?
Yeah, I knew that it would be this question. I think that such notion as integrity cannot be jungled in a way whether to measure or not to measure it. I think that integrity, whether it is or it is not there. We cannot say that the person has integrity at 70% or 60%. I think it's already a little bit of, of manipulation of terms, so to say.
Terms?
So I think that integrity is such an integral category. We can't measure it using some percentage. It's either there or it's not there.
In your view, that even a minor or less serious violation of ethical standards or integrity standards causes the result that the person has no integrity?
Violation of the integrity standards is, of course, shall lead to some consequences, to my opinion. The issue is what will be those consequences. So we presume that there is a violation, but based on the circumstances when such violation is committed, maybe it's possible to envisage some kind of sanctions, but it's definitely that each violation, including violation of ethical standards, should lead to some consequences. That I think it's true.
Consequences is one thing, but we are discussing conceptually, and your first answer was clear. You either have it or not. And now I am talking about the challenging question, and this is not an exam. Don't worry, I won't grade you. It's an ongoing discussion. People disagree on this many times. But if you say that you either have it or not, what if there is a not super serious violation of these standards, but there is minor violation? If it is binary, the person doesn't have integrity because you either have it or not.
Very tricky question.
But you knew it in advance.
Yes. So I can't complete my answer just in. Я не можу чітко відповісти.
I can't give you a clear answer because, yeah. So definitely, I stand for my position that integrity whether is there, whether it's not. Test один, test works. Okay. So again, that's the question, whether this integrity is violated, if the integrity is violated, whether it's violated with intention or not, deliberately or not. Because if the violation is committed deliberately with intention, of course, it nivelates the integrity of this person. If the offense is committed unintentionally, because of some circumstances, because of some independent circumstances or events which are not under control of a person, then it could not be a sign of the lacking of integrity if that person took all possible measures to mitigate, to minimize those things. It could be just an accident. Here we cannot say that this person lacks integrity.
And now we move to the real life from the conceptual theoretical heaven.
Okay.
You said in one of your responses that it would be unethical to come to your supervisor, member of the High Council of Justice, and say she's doing something wrong. Why do you think it would be unethical?
First of all, subordinating relations. That's definitely about subordination. I can express some of my thoughts regarding the behavior, and here is the behavior of a person, that their personal attitude and perception of actions which she commits. I can or I could express at that moment my position, and now as I'm working with HCD member, I also can express my position regarding some aspects of my work, whether I agree or do not agree with some conclusions. But all of us, we are adults. All of us, we consciously make some decisions, and we make those decisions with awareness, and so we choose some models of behavior. And if this person made that decision and acted like that, then for me, it would not be that correct to come and say, just there, my opinion, to express my opinion. Not that when I'm not asked, but to express my opinion just because I want to express my opinion. I have my own beliefs and my own standings, but a person is responsible for their actions by themselves.
Follow-up question will be about whether you consider this principle of subordination, which definitely in the world of civil service or state administration employees is an important one, whether it is always the one which the civil servant should observe, or whether when there is a very huge tension between the action of the supervisor and the core mission of the institution, if there is a huge tension, whether there is some space for the subordinates to express their opinions, regardless the principle of subordination. If the wrongdoing is that bad, whether there is some space to express opinion. What do you think? Or it is an absolute principle and you should simply, we are adults, you are responsible for your actions, I am responsible for my actions, I will not say anything.
The law on the civil service envisages such cases when a person could refuse to fulfill some functions or tasks, but no single law regulates such category as ethical category. And here, each of us shall make their own decisions. Civil service, including the issue of subordination, are quite well-defined categories, and there is not that much space for actions. Again, here we need to take into consideration the general context. One thing is when you do not agree with some specific act or action of a specific person, and another thing when such specific act or action, such certain act or action is considered to be normal on the level where this person is. We cannot ignore it. Each of us makes their own decisions for themselves, how we are going to act in this or that situation. As I mentioned before, you bear responsibility for your actions. Speaking about civil servants, you know, such questions are difficult for civil servants because in major part of the cases in such situations, your work is under risk. It, you know, there is not that much, how to say, that space for maneuver.
I have two more, if I may. I was very happy to hear about the case when you reported the unethical/illegal behavior of the judge who asked you to do something illegitimately. With regard to the direct supervisors, would you agree that your primary principle guiding your steps is loyalty? No?
No, definitely not. The key principle for me is proper fulfillment of tasks which are assigned to me with respect to law and my certain internal beliefs, but in no way with no consideration of my attitude to this or that person, because it violates the key principle which I mentioned in my presentation, that's the principle of independence. Now, I'm independent in my actions if I'm assigned, if I'm appointed for this position. No single subjective attitude regarding any persons, including members with whom I work right now, would not be a decisive one.
Okay, I would like to continue this discussion for longer, but we don't have time. The main question which would be on the table is whether really in your position, to what extent you are independent. I feel like your current position is different from the future position of inspector, which will probably have more independence than you have now. Is it so? Or you see the level of independence in your current position on the same level as the inspectors?
For now, so for now, at my work, I'm fully independent at my decisions. Till now, I didn't have any single case or situation when, for example, an HCJ member doesn't agree with my position or we failed to reach the consensus. I work with files, so by myself, and I express the position which I have, and the HCJ member usually agrees with my position, and I can express some doubts, some objections, my opinion. At my work right now, I don't feel that there are any limitations for my activities.
Same level? Just very short answer.
No, not the
Okay,
same, because final decision makes my member, Pan Lukyanov, and responsible for this decision is his responsible in the main task.
So there is a difference.
Of course.
Yeah, thank you. Probably my last question. Maybe my perception is totally wrong, but when I listened to your first interview 3 months ago, I think, and when I read the answers we got to the questions we had in the preparation, I see now today, I would call it a higher level of openness to have a critical opinion about your previous supervisors. In the written answers, as well as in the first interview, I think you were quite reserved to express criticism towards people whom you worked with, whom we discussed. Today, my perception is that you were more open to express. It's a matter of fact, there were serious issues with these people. Is it my perception correct? Is there a difference? Are you more open to criticize them, or is this perception wrong?
My personal attitude regarding those issues is the same, but maybe today I'm more ready to such questions. Because I had already the previous interview. Of course, I watched the previous interview. I have been reflecting for a long time on that matter. So I reflected on the question that you asked me. And my position has not changed, but maybe this time I'm more ready. I'm more ready not to speak about it, not like that, but maybe to comment on that matter. Because first time, frankly speaking, and I'm going to be frank with you, I was a little bit lost when you asked me those questions. That's my absolutely frank and sincere reply. I think that my reaction was absolutely obvious last time. Maybe at that time, at that very moment, I was not. I was a little bit lost. First of all, for myself, I was not oriented on the questions. But again, I would like to express and underline that maybe today this position, my position, is more clearly expressed, but it definitely has not changed.
Yes, please. I think
Пані Олександра,
Dear Alexandra, I would like to return So the situation which you have shared with us regarding you when you submitted the report on commitment of a crime. So when you shared that story, you mentioned that you blocked the phone number of the judge. And how did you have that phone number? Had you had any previous communication? Yes, so for sure. And I mentioned it that and also the documents they provided. I explained, and also it was mentioned in my notification that there had been a previous communication based on the agreement with the High Qualification Commission member. As we had very strict deadlines to prepare files, we had made calls and informed that you are going to get equations on, and you called from your personal number to him, not from your working number, using your working number. I don't remember for sure for now, but I think at that time, for the first time, we had called from using our working phone number, but so now at the HCJ, the same as it had been in the HQCJ last time, we don't have the direct work number. When he calls back, he will be waiting for a connection and so on. Thank you. Well, another question. Did the judge pass qualification exam? As far as I know, not. I'm not. Frankly speaking, when I prepared myself to this interview, I visited the website of HQCJ to see whether he passed or not that qualification exam, and I didn't see any decisions him passing that exam. But the files were under your member case. I will explain. That situation happened one day before the interview. Next day, there was no interview. I don't remember why, whether it started or not, but maybe it was just cancelled because of that situation. But at that time, there was no final decision made. And as far as I remember, we didn't put those materials before the mandate of Slenko was terminated.
It's been a long interview. I have just a couple follow-up questions. You referenced when you managed a group of, I think, about 4 people at the parliament, Verkhovna Rada. What is the most number of people that you have supervised or managed?
After that position that I mentioned, I was appointed to the position of the head of Department of Legal Matters. If I'm not mistaken, the maximum number of people was 7 or 8.
Right.
Yes.
Okay. And how long did you manage them?
Maybe months. I don't remember correctly now.
All right. All right. We are going to shift now to issues involving integrity and property integrity. We reviewed most of these issues in your last interview. There were some additional issues that came up. You responded to those issues. Those issues have been responded to my satisfaction, and I think you answered all the questions that our assistants had asked you, and I feel as though they were responsive and answered any questions that were outstanding. So I will defer to my other colleagues if they have any follow-up questions on property integrity or other integrity. Okay. Thank you very much for your patience and responsiveness today.
Thank you very much for your honest answers and considerations and sharing honestly with all the concerns that you have and had. And now there is a time for your final comments. 2 minutes, if you wish.
I'll be quick, very quick. I want to thank you. Я дякую вам.
Thank you for opportunity to participate, for voting trust to me when you recommended me for the position of an inspector. I hope I was able to answer to all your questions, or to clear all the doubts about myself that you had and which I recognize, and I wish you to select the best.
Tomorrow afternoon. Good luck and have a good day after this quite tough interview. Thank you.
Дякую.
Dobry день, good afternoon. This afternoon we will have the interview with one of the candidates for the position of the head of the disciplinary inspector service, Mr. Vyacheslav Pleskach. Good afternoon. First of all, I would like you to introduce to our commission. You already know the commission, but just to remind you that all 6 of us are present here today. So I'm Reda Moliene, the chair of the commission, and the commission members are as follows: Yulia Bokova, Olena Kovbi, Olga Popikova, John Ehrlich, and Pavel Zelinchik. So our interview will last for about 1 hour. Sometimes it is a bit extended, sometimes not just a bit, but we will try to do it in an hour or so. And first of all, you will have an opportunity to present your vision, your motivation in your presentation up to 10 minutes. Then we will have a session of questions regarding your professional competence and integrity. At the end, you will have some opportunity to have some final comments. The interview is, as you know, broadcasted. If you have any information which falls under restriction for its public disclosure, please inform the commission accordingly. And you are kindly asked to speak slower because the interpretation is going, and also to be as concise as possible in your answers so that we can have a discussion on all important aspects of your qualifications. Would you have any requests regarding composition or? Thank you. So we can proceed with the interview, and this is the time for you to present your vision and your understanding. How are you going to build the service if you would be appointed? And the floor is yours, please.
Dear members of the selection commission, dear observers, if we have any, as that's my second time to participate in such interview, I will omit this parts, as I have been dreaming about such systems since the childhood. According to the law on the HTJ, one of the most influential functions of the head of SDI is to assess activities of the discipline inspectors, and that's what I'm going to focus my attention during preparation to this competition. This presentation I have already sent to the selection commission members. That's why I'm going to comment upon only some crucial things. So on this slide you can see those informational resources which I used while preparing for this competition. So informational sources which I have used to prepare for this competition. As we discipline inspectors work with judges, so discipline inspectors face similar requirements as the requirements for the judges. That's why I thought that it would be logical to use those sources of normative acts which are related specifically to assessment of judges. That's why in this regard we used international information resources related to judges assessment because, and that's the most important, those acts were approved by judges for judges, so we can expect that there were some specialized discussions with involvement of judges. Definitely those judges have expressed their own positions on how to maintain a balance between appropriate assessment of judges and to guarantee their independence. So we can say that such acts consider the balance of such values. So first of all, one of the key sources which I used to prepare for this interview, it was the draft law of the Republic of Armenia. It's published on the website of the Venice Commission. So it's in English there. It's quite a comprehensive memo attached to it, and it says that the authors of this draft law used international experience, and actually I found out from that memo that specifically in Lithuania, for example, there is a separate regulation or procedure on assessment of judges. Also, this report gave me this information, and I use this information in my presentation. Next slide. So my concept of assessment of disciplinary inspectors is the following: that we need to take into consideration qualitative and quantitative indicators for assessment of inspectors. And here on the slide you can see a list of such criteria of qualitative and quantitative criteria. So some comments. First of all, I think that in Ukraine there is quite a negative application of qualitative criteria of assessment in the judiciary system. For example, this was a competition for the Supreme Court when some qualitative criteria were quite doubtfully used during assessment. That's why I understand that the selection commission members from the side of Ukraine could have some skepticism, and I partially agree with it. But anyway, I think that it could be and it's appropriate to apply some qualitative criteria for assessment of inspectors. And I will dwell upon on some of those criteria. First of all, the first one, ability to ability to effectively participate in the consideration of a disciplinary case. As I mentioned before, at my previous interview for the position of the deputy head, I think the disciplinary inspectors should actively participate at the disciplinary process in comparison, and HCJ members should take a more passive role in order to transfer the burden of proving from the side of HCJ members to the side of discipline inspectors. HCJ members should perform the role of a judge more, of a role judge, and inspectors should more prove the factual circumstances of the case. That's why one of the abilities of inspectors is to effectively present evidences in front of the disciplinary chamber, to submit a motion, to ask questions to witnesses if there are any, to reply effectively to questions of the chamber members if there are any. And I suggest to evaluate all these aspects on the basis of randomly selected disciplinary cases. Why randomly? Because it's clear in order to minimize the subjective factor risk of influence by the SDI head to avoid situation when the SDI head chooses any indeed some specific cases where disciplinary inspector showed very good results or very bad results. And the last criteria. So, also speaking about quantitative criteria, the last criteria, I'm sure that the Commission members from the side of Ukraine could have a question to me, the number of opinions based on which disciplinary chambers issued decisions on the merits of the case. In Ukraine, we have such, in the prosecution authorities, we have such a practice when prosecutors are required to issue a specific number of indictments, and in order to ensure for prosecution of some specific persons. And so if a prosecutor achieves this threshold, it's okay. If not, there could be negative consequences. So in such case, I would not demand for bringing to responsibility such judges, but anyway, there should be some requirements for inspectors in order to ensure the specific number of consideration of on the merits of the case. So, for example, if a disciplinary inspector has five decisions on refusal to bring into for a judge to disciplinary responsibility, would be assessed on the same criteria, based on the same criteria as other disciplinary inspectors. So there should be decisions on the merits of the case, but whether there will be an indictment or whether it will be non-indictment decision. So what would be the final decision? It's not already the responsibility of a disciplinary inspector. The next slide. Here, I will mention some main principles that should be applied during assessment of inspectors. First of all, I think that it's important to the compliance of inspectors with the criteria shall be presumed, and after I completed this presentation and I shared it with the selection commission, the draft procedure of the High Qualification Commission of Judges for assessment of judges was published, and this principle also is envisaged there, that a judge already complies with the criteria and with so I think that my opinion agrees with the opinion of the HQCJ. Also, I think that it's important for inspectors to provide their own self-assessment. Of course, self-assessment cannot be a trustful source of information, because in our heads we're always the smartest, the coolest, the most beautiful. But anyway, it should not it should not cause, it should not harm the practice, the health atmosphere of healthy criticism in SDI. Also, I think that next proposal could be quite discussable, and to create such as collective assessment for inspectors, because it's not envisaged by the law. Here, I suggest to involve members of the HCJ, of HQCJ, if anyone agrees, because they have also so much work. But anyway, I think that it's a very important factor and tool to mitigate subjective assessment from the side of the head in order to avoid such situations when the head is too strict or too soft in his or her assessment of activities of different inspectors based on their own preferences. And the fourth slide, that's the general timeline and the order of assessment. So first of all, I suggest to have periodic assessment and extraordinary assessment. Extraordinary should be done at the recent request of the High Council of Justice and its disciplinary chambers. So first of all, the key tool there should be to take into consideration the feedback on activities of inspectors and on feedback from the side of HCJ. If HCJ members see that an inspector makes significant mistakes or has some significant drawbacks in his or her activities, they can reach out with a recent request to have an extraordinary assessment for such inspector. According to the law on the civil service in Ukraine, it says that if a civil servant fails to pass an assessment and gets negative scoring, he or she could be dismissed. I think that it's quite a neutral tool to get the feedback from the HCJ members in order for us to evaluate inspectors based on their experience of cooperation with inspectors. But at the same time, it will allow us to mitigate any possible risk of non-formal influence from the side of HCJ members. And also, I understand that maybe my forecast here is quite optimistic, and here I say that SDI starts working since the 1st of January, so it could be. So I suggest to have the first test assessment in 6 months upon results of the first 6 months functioning period. So first of all, I suggest to have this assessment in order to allow inspectors to start their work, to gain some experience, both negative and positive, at their positions of an inspector, and to mitigate some drawbacks at their work before assessment starts. And also during these 6 months, we can also test the methodology of assessment of inspectors, because we need to assess how adequately we can collect some statistical data, whether we can adequately assess the conclusions prepared by the inspector. So this test assessment would be useful both for us and for inspectors themselves. And the last assessment, I suggest to have during the last 6 months of functioning of the SDI, because such findings of the assessment would be also useful for the selection commission when the next competition takes place, and for the roles of the SDI. The huge number of inspectors maybe would like to apply for the second term to hold this position, and such results of the last periodic assessment would be useful for the selection commission. That's my opinion. At least that's my vision of this institution. That's all. I'm ready to answer questions.
Thank you very much indeed. In your motivation letter that we have in our materials, you presented a very detailed approach and vision how to build the service and the steps how you would build. Here you emphasized one very important aspect of the activities, so thank you very much. Maybe we will come back to your vision and motivation in our questions. And now I would like to give a floor to Pavel Zelinsky to start our session and discussion.
Good afternoon.
Good afternoon.
My first set of questions will be about your experience in leadership. If you can tell us, in your documents we found a lot of information about your vision and steps how to achieve that vision. Can you tell us more about yourself? And I know that this information to some extent overlaps with the previous interview we had in August, but we are in a new selection process now. So please, if you can tell us, how would you evaluate your leadership experience? Where did you get this particular experience, and how many people did you manage?
Mm-hmm.
Thanks.
I started to work at a managerial position, and when I was 23, I was appointed as a director of one of the private company. As for my managerial experience, throughout my professional life, I had up to 10 people under my management and under my command. Not all of them were lawyers, only 2 of them were lawyers, so other persons was more like technical personnel. So about SDI, it will be obviously difficult for me because I had not such experience about when you have to manage up to 50 people. But I think I'll get it. So it's
Why do you think you will be able to do it?
I had many challenges in my previous professional life, and most of them were difficult. But I managed to overpass every challenge. So I am optimistic in this regard.
Okay. Procedurally, I would like to know that we ask every candidate to respond to 1 or 2 questions in English. You just did it before you were asked, and we appreciate that. But to make a fair playground for everybody, you can choose whether you will respond to my following questions in English or Ukrainian. It's totally up to you.
Okay.
Thank you very much. Can you please tell us more about your work for the legal department of the Consumer Society in Bakhmut?
Mm-hmm.
What kind of legal work are you responsible for?
Так, це приватне підприємство.
Yes, it's a private enterprise which mainly provides services on the real estate, both in ownership and in lease. We have quite a high number of property which we lend, and at their enterprise first I've worked as an accountant and as a lawyer. Under my scope of functions, I work with agreements, with claims, and I have 1 lawyer under my subordination. That's a young guy who is 25 years old, and this work doesn't take significant part of my working time. I'm a part-time employed there at that enterprise. So yeah, that's mostly the work related to the claims issues, and they represent interests at courts.
With regard to the Jure Foundation, can you mention the types of work you were doing there during your career?
З де Юра, з фундації.
With the Jure Foundation, I have been cooperating since 2021. You know, I'm not sure whether you are aware about this organization and to which extent you are aware about this organization. It's a civic organization which works in the judicial reform sector, but that's not the only type of their activities. The key area of activities of this organization is the issue of openness of activities of the of legal authorities at large, of judicial system, prosecutors, attorneys. Now they have very interesting cases where they submit so many different suits against them. So against bars, self-governance authorities. For example, right now, bar self-governance authorities, they do not publish decisions, and impacts actually on the transparency of the activities of the bars unions. I was engaged into activities of this organization, specifically in this sector, on analysis of the openness and transparency of activities of the state authorities. My friend, which at that time worked as a lawyer at that organization, he suggested for me to be a reviewer for the article which is related to the openness and transparency of the activities. So we have the unified register of court decisions in Ukraine, which should include, should be fulfilled by all courts and all judges regarding decisions. So there could be a situation when information could be filled in there, and then it's just somehow lost, or information is never filled in there. So we wrote an article that sometimes court decisions could be omitted by the system and were not included in the system. So I wrote that article, and since that time I have been cooperating so much with that organization.
In September of this year, I took part in drafting based on industrial capacities of the euro, we were writing an article about qualification evaluation of judges. This evaluation is conducted by the HQCJ, that is another body, but in this article I took part in writing of a section that is about the case law with respect to the HQCJ and HCJ. And out of the recent cooperation directions, we've prepared analysis. This will be a great materials. It's ready but not published yet. And that is a material about dismissal of judges. In our legislation, we have many problematic aspects regarding dismissal and retirement of judges. And in this analytical paper, we will discuss foreign experience case law of the HCR. So I think once it's published, everyone will be interested in reading this article. It will be useful. So that's briefly it.
From both your motivation letters, I got the perception that you are a visionary who a lot uses comparative knowledge, using examples from other countries and so on. And you even proposed what should be changed, what should be adopted from which legal system and so on. Can you please elaborate how such a strive for free spirit and ideals in legal, in the perfection of legal system, on one hand, how it will work in the current framework, which is determined clearly by the law, or more or less clearly, what would be going through your mind, knowing all these good systems and wanting to have them here, but at the same time being restricted by the current state of things in Ukraine? Is there a conflict, or you feel perfectly comfortable working under the framework which we have now here?
Так, це дуже проблематично для мене.
Yes, that's a very problematic issue, because there are some things which other people see, and the current, so there is the current situation and the situation that you would like to see. You would like to see some legislative regulations, some ideas. And for me, it would be problematic that to understand that it could be great that we could take into account this particular foreign experience, but we have to work within the framework of these boundaries. So for me, it would be unpleasant to know that we could work better. But in any case, we should work in the current situation, even if we cannot change some aspects, even if we cannot introduce some ideas into reality. Still, we need to be looking for some possibilities to implement these ideas, even within the framework of the current legislation. So it's possible. Not all ideas can be introduced and implemented without legislative amendments, but many of them can be introduced at the level of ordinary practice.
And my last question in this round, and I will have some more later, is a conceptual one. Concept of judicial integrity. In your view, is it binary? You either have it or don't? Or you can scale integrity and have certain level of it, even if not full? What do you think?
Ну, на це питання, мабуть,
Probably my answer to this question would be like not by everyone. Now I'm working as the attorney, and one of my clients right now is a sitting judge. And by the way, today she's been interviewed for the position of the HQCJ, that is a judge from Poltava. She is quite well known. And her situation was the following. At some stage of her work, she was offered a bribe. A very powerful politician in Poltava came up to her and offered her money for taking a decision in his favor. She refused to do that. She turned to law enforcement bodies, and based on that, there emerged a very aggressive conflict with judges of her court. And at some stage, let's call it like she said some unpleasant things about other judges, and she was brought to disciplinary responsibility after that. Then this decision of
she said that publicly or in the group of judges or in small group, big group? What was the audience, just so I understand where her expression was executed?
Вона це
She did that in the social media, in Facebook in particular. And after that, she took part in the competition for the position of the member of the HCJ, and she was recognized as lacking integrity. Because of this aspect, when she criticized other judges, she was recognized as lacking integrity. And now I'm, as the TONI, represent her interests in the European Court of Human Rights. And once I'm looking at this situation, of course, I understand that integrity is not a binary concept. Like integrity can that's what I started from. I still believe that morality in some aspects can be a gray area. There are no black and white people. There are good and there are bad deeds. Good people sometimes can make bad deeds. Some bad people can do something good sometimes. So context should be considered in any case. You just cannot put a label that this person has integrity all the time and this person does not have integrity all the time. So that's my vision.
That's all from me for now, and I would like to offer the floor to my colleagues.
Good afternoon, Mr. Vyacheslav. I would like to ask you the following question. In your motivation letter, the first step at the position of the head of the Service of Disciplinary Inspectors, you specify the following. I would start studying a biography of inspectors appointed and following the elimination of incompatibility circumstances. Why would you start from biographies of inspectors and where will you take this information? First of all, that's information published at the website of the HCJ. That information was deleted from there later on, but I had time to save it for myself. So I already have biographies of all disciplinary inspectors, just in case. And secondly, we have public interviews. I can watch interviews. I've already watched many interviews. There were some funny moments. It was also interesting to watch something. And sometimes that people were providing acceptable answers. Why is it necessary? Because this is a new team. People come from very different backgrounds. It's necessary to understand with whom you are going to work. And that's also about the problems to be faced by the inspector. For example, if the inspector used to be the judge's assistant, it is necessary to see and understand which decisions this person is taking with respect to those judges where he or she was the assistant. And so facts from their biography should be kept in mind all the time. I can probably imagine why you've asked this. I'm not going to start studying the personal life of inspectors, but I need to know the professional life of inspectors. I need to know with whom I'm going to work. And secondly, I think that in case I'm appointed as the head of the SDI, maybe we can form some groups or working groups on improvement of the legislation or something like that. And I would need to know whom I can involve into these working groups. For example, I see that there are academics, there are people who work as assistants of judges of the Supreme Court. There were very different candidates. For example, some of them worked in the NACP, NABU. These people can be involved into this work regarding assessment of integrity of candidates. That's what I've shown in my presentation. And it's necessary to know that. With respect to incompatibility, then according to our legislation on the civil service, you cannot be an attorney or hold some other position. You cannot be the individual entrepreneur, and dismissal is set out if the person fails to remove this fact of incompatibility within 15 days. And I would also need to control this aspect so that inspectors would not make some childish mistakes. But that's the responsibility of disciplinary inspectors to eliminate incompatibility. Yes, but it's necessary to have some co-responsibility at least. I understand that that's a personal case of inspectors, whether they will do that or not. But for example, if I see that the person is going to commit an offense, then I think that I should interfere and explain that, for example, if you do not suspend your attorney's license, then you can be dismissed from the HCJ. Okay, thank you. And my next question is also about your motivation letter. In your motivation letter, as the second step, you specify that I would look through informal practice of disciplinary complaints. What informal practice do you mean? I imagine that there are things that are stated in some bylaws and laws, but with respect to, for example, how documents are transferred from one unit to another unit, how they get information, how they enter all of this information into the database. As far as I understand, you have some specialized software. And as the man who has never worked in the HCGA, I do not know how it looks like. So I can get familiarized myself with the informal level to understand which aspects should be preserved, maybe some should be improved, something like that. Okay, thank you. Hello. I have several questions to you. Can you please tell me what is your attitude to the fact that the head of the SDI may perform the functions of the disciplinary inspector? That's the question that Pavel has asked as to the current situation and how I would like to see the situation. How it is right now. I'm not against the head of the SDI performing these functions, but at once, in my opinion, the HCJ does not have the power to delegate these functions to the head of the SDI, because the law states that the head of the SDI performs other functions set out by the HCJ. But frankly speaking, I think that it's quite liberal to interpret this provision in such a way that the HCJ can authorize the head of the SDI to perform functions of the inspector. If we interpret the law like that, maybe the HCJ can delegate these powers also to the head of the secretariat. The law does not set out that directly, but the law does not prohibit the HCJ to do that. So I'm not against the head performing some functions of the inspector to some extent, but in the context of legal vacuum, I do not think that it would be a reasonable decision, because if the head prepares opinions just like the inspector, then this decision of the HCJ can be challenged in the court based on formal grounds, because the opinion was prepared by the person who does not have these authorities. What if the HCJ adopts the regulation tomorrow that the head of the SDI would perform functions of the inspector? I would try to convince members of the HCJ not to do that. But of course, if such regulation is adopted, I will follow this decision of the HCJ. Okay, how do you see your interaction with management of the HCJ, with members of the HCJ, if you see it? Yes, that's an interesting question. When I was studying the legislation on the civil service, I have identified sort of a collision, sort of inaccuracy in the legislation. In the law on the civil service, we have such a notion as the head of the civil service. And with respect to the HCJ, the head of the civil service is the head of the secretariat. In this respect, I've addressed the National Agency on the Civil Service, and they have provided the response to me that they believe so as well. And in the law on the civil service, we have some provisions which overlap with authorities of the head of the SDI. There might exist some conflict between the head of the secretariat and the head of the SDI with respect to some powers. So in this respect, by the way, it would probably also be necessary to clarify the law. The law can be fulfilled without amendments, but in order to minimize conflicts, probably it should be done. If we are talking about the current legislation, I'm sorry, which conflicts do you mean? What which conflicts, in your opinion, might emerge because of this situation? For example, according to the law on the civil service, there is such notion as a disciplinary commission. It is established by the head of the civil service. Then, for example, if we have in the SDI disciplinary proceeding with respect to an inspector or with respect to employees who are not inspectors, because there will be other stuff as well, then this commission will be established not by the head of the SDI but by the head of the secretariat. And it might happen that if we have a conflict between the head of the SDI and the head of the secretariat, then the head of the secretariat may fail to include the head of the SDI into such commission, and then the head of the SDI will have to follow the decisions of this disciplinary commission, the member of which he is not, but he will have to submit to decisions of this commission. So there is potential for conflicts. If we fulfill the law in a very good way, then there will be no conflict, but we should also to pay attention to the fact that good friendship is a friendship that is stated in a good agreement, and the law is an agreement to some extent, so this aspect should be clarified. You have a very interesting position, so you are not appointed to any position yet, but you are talking not about some positive aspect, but about conflicts at once. That's a very interesting approach. Without starting to work, you are already forecasting that there might be some conflicts. Okay, if conflicts emerge, how are you going to resolve them? I'm sorry. If you disagree with something, if you foresee that by default it will lead to a conflict, how are you going to resolve it? First of all, I'm an optimist. I believe that conflicts should not exist. I would not agree with you. I'm just a supporter of the idea that we have to be prepared for all options. So that's my thinking. Maybe it's like professional deformation based on my previous places of work, but that's it. With respect to resolution of conflicts, it all depends on the level of the conflict. The level is you and the head of the secretariat. Then, of course, at first I would address the chair of the HCJ. If the majority of members of the HCJ have selected someone to be the chair of the High Council of Justice, then it means that they trust him. So I would address the head of the High Council of Justice first of all. If I can't resolve some aspects on my own with the head of the Secretariat, and if I see that we have a conflict that cannot be settled by us, if the chair cannot resolve the conflict as well, then I would raise this issue at the plenary session of the High Council of Justice, so that the members of the HCJ would express their position. How would you phrase this issue that you would suggest to discuss at the plenary session of the HCJ? We are talking about some hypothetical situation. Yes, but you are forecasting it, that it can emerge in connection with the gap in the legislation. For example, if we are talking about the situation with disciplinary commissions, then I will just describe that the law sets out that disciplinary proceeding within the framework of the SDI is the power of the head of the SDI. If the head of the secretariat will say that he is like trying to undertake these powers, then I will explain in this submission the situation. How would you phrase the question and issue, and what expectations would you have? For example, if we have the situation that you've just modeled, if we're talking about, simply speaking, without formalistics, I will describe the situation and I will ask the High Council of Justice, are you supporting me or him? So that they would explain it to me, how we are going to act in this situation. It's a very weird wording, are you supporting him or me, as for the head. In this particular situation, that's your vision of interaction with the head of the secretariat, so with your immediate supervisor. And how do you see interaction with the management of the High Council of Justice, with the chair of the HCJ?
So, with the head of the HDJ, yeah, the deputy head and the head, yeah, these are people who define the HDJ policy. So here it would be inappropriate to have some kind of a dialogue and discussion regarding those matters, how we move forward. For example, if there is any conflict situation covered in mass media regarding some activities of SDI or decisions of SDI, such communications should be agreed with the head of the HJ at least. Not to go to the public with your own statements without previous agreements, but to explain that there are such situations and public negatively covered in mass media. Let's discuss. What do you think about it? My position is the following. So, what could be a conflict situation between the SDI and mass media? Well, I don't know. For example, a disciplinary inspector happens to be at the compromising situation. For example, he is pulled over being drunk while driving the car. Okay, thank you, clear. Last question. Are you a military obliged person? Yes. When did you update your data? Through Center of Administrative Services in May this year. So this year, yes. Are there any issues, any questions to you from the side of the conscription officers? No questions to me at all. Thank you. If I may, Vyacheslav Yurievich, I would like, so first of all, to say thank you to you for your motivation letter. For me, it was very interesting to familiarize myself with this letter because you were very creative and meaningful while drafting this letter, and I could say that it's a very good tool which lets us know more about yourself, about your vision and your thoughts. So first of all, thank you for this, and secondly, I would like to use the information which you provided in your motivation letter. In particular, it's a very interesting very interesting your wording of the conceptual risk and activities of the Service of Disciplinary Inspectors. I'm sure that you remember that part where you were reflecting on the rebooting of key authorities such as HCJ, HQCJ, and other key institutions of the DGI sector, and understanding the expectations of the society, of the public, specifically regarding the illustration process for the judiciary system. But at the same time, you also state that for the leadership of the Service of Disciplinary Inspectors and disciplinary inspectors themselves, they will need to find this wisdom how to implement properly functions of the Service of Disciplinary Inspectors, but at the same time not to be under pressure of the exaggerated expectations of that kind. Can you develop on that topic? How to achieve this balance between, indeed, proper implementation of functions by the service, and at the same time not to be influenced by this pressure of those exaggerated public expectations? Yeah, of course, it's a very difficult question because you formulated it in so wide manner. Yeah, all of us will understand. So what pressure we are meaning here, because the society expects from us some decisions regarding specific judges. There will be the public and mass media having some articles and publications, and this judge is bad. Let's do it very quickly. Let's deal with this problem today, tomorrow. But here we need to look for and have this understanding. What are the guarantees of independence for judges? Because without this understanding, we will not be able to achieve that balance. We need to have this understanding and to explain to some extent to inspectors what it is. Because among inspectors, there will be new people. Some of them will have no previous experience in the judicial sector. Maybe some of them have never attended course at all. So I could expect that there's could be such a challenge for the SDI activities where new people will issue negative conclusions for judges very actively. They will see everywhere such, negative aspects. So we need to respond not only to those cases when an inspector is so soft in treating and considering the case of a judge, but also other cases when an inspector gives negative conclusions to each and every judge, and this is a bad, that should be dismissed, and so on. So here, some outreach activity, some explanational activity should be done. Yeah, but anyways, there is some to reflect, something to think about. Yeah, you're right. I don't want to abuse my time. I have only one short question to you. So, to your opinion, should disciplinary inspectors be assigned to disciplinary chambers? Because that's a quite an acute issue, important for the further functioning of the service, and it should be also maybe covered first of all by the regulation, because it's related to the arranging of the operational process. I'm fully against this assignment to the chambers, and there are two reasons for it. So first of all, if inspectors are assigned to specific chambers, then all statistical data regarding their activities will be distorted, and it will not be representative. For example, and in my situation, for example, there is an inspector who prepared 90 conclusions. 30 go to first chamber, 30 to the second, and 30 to the third chamber. First chamber considered all cases, second considered all cases, the third returned 15 cases for improvement, for finalization. Here we can think that maybe it's not the problem of that inspector, but maybe it's a problem of this specific chamber, which could have some specific requirements regarding those conclusions. Maybe it's worth to have a discussion with the HSJ members in order to unify approaches and principles for conclusions. Second reason, I think that would increase and will have the very high risk for inspectors, how to say it, to be in the gravitation field of the HSJ members with whom they would work. Here I would compare the dynamics of works between prosecution services and authorities and courts. There could be such a problem when there would be either so extremely friendly or extremely adversary relations. If someone doesn't like the decision of another person, and then they're trying to to decide and to solve it in an informal manner, so it would impact so negatively on the decision. So I think that it would undermine the independence of inspectors. They would become under influence of HSJ members to whom they will be assigned. That's why I'm against it. I understand your risks, and yes, there's some sense in what you have mentioned. The only thing I would like to mention is that as inspectors have quite an active role, and they also are rapporteurs on the cases, and they should they are entitled to participate in proceedings. It means that from another perspective, there is also a question how to arrange this process properly, because chambers have meetings on different days. So, you can't spend all your working time just going from one meeting to another. Yeah, I understand you. That's organizational issues. That's a problematic issue. That's a challenge. But looking from the global perspective, I'm against.
I would like to come back to this professional competencies and skills, and it's kind of obvious that you are, as a professional, more as a person of very much into analytical thinking and basing all your decisions, conclusions on profound examination of facts, information, comparative information, etc. Would you see in any situations this as not advantage, but rather than disadvantage in the work of the head of the service?
Maybe, if to be such a extremely visionary, to focus as how it should be rather than how it is. You know, it's related to the question of Pavel Zhelinchik, whether a person is capable to work with what is at hand rather than to what is ahead and some things from foreign practice, international practice, so on. But I don't see here any problem. I think that it's possible to achieve this balance between what you want to have and what you have.
As any leader of the organization or a body, sometimes or even often faces the situations when he or she has to make a decision very quickly, effectively, efficiently. There is no time. Or, for example, some crisis situation. We have to decide here and we have what we have, and there is time to make a decision because nobody would do instead of. And if they would do, it's not so good. So would you see it as some kind of like a challenge for you in these kind of situations?
No.
Not having those, bunch of materials and feeling confident in what I'm deciding because I have analysis and I know what I'm doing.
Ну, я не знаю.
I'm not sure that I can. It could be considered as my advantage, a drawback, but I am a person with very quick decisions. I'm related to a category of people who sent a letter to Santa Claus in the morning, and in the evening I'm waiting for his reply already, and I'm looking into the mailbox. So sometimes it's useful at my work, but at the legal sector, very often that's a drawback. Disadvantage because legal sector is not very dynamic because you can submit a motion in the morning and you will get a conclusion decision in several years. And for example, now I receive decisions from the Court of Cassation regarding suits and which I submitted many years ago. So it's a problem for me sometimes because I don't need to make quick decisions, rapid decisions, but I need to go step by step or very consequently. So it was, actually controversial. It's my feature to make quick decisions, rapid decisions.
From this leadership challenges or advantages working with teams, you mentioned that you do not have much of experience working with big teams of people. And in your motivation letter, which is really very detailed and it's very helpful because now we have a picture in front of us of your vision. I noticed that in those stages or steps that you foresee as the very important steps in building this institution, you emphasize organizational, logistical, technical, regulatory measures, and I kind of miss a little those things that are related to building the team of very different people with different background, different understandings. So maybe from your experience and perspective as an employee, not the employer, how do you think, what are the main expectations of people coming to new institution, seeing new leader? What is the most important to make them be motivated and stream to do something better?
I think that even from my perspective as a candidate for the position of an inspector, I think that one of the biggest challenges for future inspectors will be just to come to work at new institution, because for a major part of them, this will be new people who have never worked in the HCJ. Maybe they have even never worked at courts. So such good atmosphere should be created for them, showing that we are ready to support them all the time, always. Maybe to have such joint meeting, to like introductory meeting, to find out more about each other, to get acquainted before the real functioning starts. Maybe to invite some interesting people who could carry out some lectures, presentations. Maybe HCJ members, not all of them, but maybe some of them would agree to share their own experience, how to work with such cases, such disciplinary cases, to listen to them in such friendly atmosphere in order to alleviate the stress, because people come at new job place, new institution. Maybe for some of them they would need to change their place of residence, as for example in my case. So to create this friendly atmosphere for people to relax a little bit at least. So that's my vision.
Of course, this is a very interesting topic to discuss further, but as we are running out of time, I will not focus on it more. I understood your approach, and this is, I think, absolutely understandable, that this emotional atmosphere and feeling confident in what we are doing and having a particular knowledge and skills, it's very important. So to build this. One more question which came up to me after following the interview, answering the question about the integrity and ethics, not this question, but about your current activities. You mentioned that you are representing interests of one judge who is running for the position of the High Qualification Commission now. About some aspects of the ethics, and you expressed some view and commented on this. And my question would be, would you see any risk of, or any problem with the ethics of advocate in doing so, in expressing some opinion on this situation and behavior of a judge who is now running for the position, and we can identify the judge if we want to, because we can see who is running from Poltava, and so it's just your consideration. Would it be in within some circumstances could be considered as a violation of the ethics?
Власне, це
Yeah, actually, the situation that I represent such situation is a public situation, and because she made a post on Facebook that I'm her representative of the court, so she published this information by herself. I don't think that there will be any claims from her side, and this was a situation related to bringing her to responsibility, and I think that I took all such, such general formulations, such wording, in order not to present it as critics against the client, because I keep being her client, and I can't criticize her as a client. So that's why I understand that's the issue, but anyway, I think that I managed to not violate advocates' ethical norms.
Dobry den.
добре.
I'm actually going to follow up on my colleague questions regarding management of disciplinary inspectors and employees. And as my colleague pointed out, you very much come across as a visionary, policy-oriented, academic, intellectual. What challenges do you think you might face in the practical management of inspectors and other employees, and how would you overcome those challenges?
Якщо говорити, скажімо так, про
If we're speaking about the holistic perspective, the big picture, I think that the biggest challenge would be for me the following. I follow the page of the Selection Commission on the Facebook, and it was mentioned that the average age of disciplinary inspectors is 36 years old. Here we can have different assessments and different positions on this matter, but for a lawyer, a 36 years old woman or man, that's a young professional. They're not on the highest level of their professional development. They still have much room for professional development and improvement. They are going to grow within the SDI temporarily for this 5-year period. Maybe they will be reappointed for the next 5-year period. So for me, it would be a challenge for me to become a source for their development. For them, not to mention the SDI is just an interesting fact in their CVs. To mention, I worked at the SDI, but no, I want them to refer to this experience at the SDI as a place where they gain new experience, increase their level, and wherever they go after the SDI, they would be able to apply this new experience in the new sector. Maybe we are speaking right now about the next future HCJ members. Maybe they're the next judges to the Constitutional Court. Maybe some of them would be HQCJ members. If such happens, I would like that in 10-15 years they recall me in their memory as a person who created for them such opportunities for professional development. So for me, the biggest problem, the biggest challenge would be to understand, to find for these people this space for growth, for development, to give them this opportunity to implement and to achieve this growth.
And how do you see your role with the deputy head in carrying out that vision for professional development of inspectors?
Ну, я, до речі, можу тут зазначити, що я в межах
By the way, I can point out that within the framework of this competition, I had a chance to meet Victoria Nedabaluk, who was recommended for the position of the deputy head. In May, when we were passing cognitive tests, on the following day we were tested by psychologists, and I saw her in the hall. I approached her to meet her. We talked for about 40 minutes with her. She made a very good impression on me. And from the perspective of the participant of the competition for the deputy head, it's a pity that I could not find arguments to be recommended for that position. But looking at the general picture, I understand why members of the selection commission chose Victoria Nedabaluk. She has experience of working in the court, in the anti-corruption infrastructure. It's very important in the country where we have obvious problems with corruption. She was answering corruption-related questions greatly. Frankly speaking, I did not work in this sphere that much, so if I were appointed as the head of SDI, I would involve her into this work so that she would share some experience, some vision with respect to anti-corruption legislation. I think that this is the sphere where she could show her maximum potential.
Areas of delegation that you can think of that you would work with her on?
Ну, звісно, мені потрібно було б
Of course, if I were the head of the SDI, I had to talk in more detail with her to find out more about her competences, because talking for 30-40 minutes in the hall, that's not enough to know the person well. But without some personal data, in the law on the HCJ, there are some problematic aspects with respect to delegation functions by the head to the deputy head, because the sphere of these functions to be delegated is not outlined, and it is not even stated that the head should delegate something at all. For example, it can happen that, roughly speaking, just a hypothetical situation about conflicts. If the head of the SDI don't know how to work with the deputy head, this issue of delegation can become a conflict problem. When, for example, the head delegates some purely formalistic, unnecessary functions which has no realistic value to the deputy head, or it can happen when the head does not delegate anything at all, and the deputy head, whom the head does not like, is just sitting in the office and doing something, whatever he or she is doing. So again, we are coming back to the question asked by Pavel Zelinchik with respect to what we have in the law and what we can have in the law. If I were drafting this law, I would envision some guaranteed functions to the deputy head. That is, the functions that the head could not take away from the deputy head, and which the deputy would have regardless of the opinion of the head. But if we do not have a chance to amend the law, then of course then we're talking about the head and how willing the head would be to involve the deputy head into work. If we're talking about specific examples, I've provided examples when we are performing appraisal of inspectors. I think that probably in practice we might have a situation when we have green so-called inspectors, when we have no comments, no concerns, they work wonderfully well. Then we might have yellow inspectors with respect to whom we might have some comments or some criticisms, and then we might have red inspectors with some obvious shortcomings. Then I would personally, as the head of the SDI, I would delegate to my deputy head green inspectors and some of the yellow inspectors where they can be appraised easily. But the most problematic inspectors where it is necessary to work thoroughly and be responsible because maybe these people can even be dismissed, then I would retain these issues.
Будь ласка.
Second part, we would like to discuss certain questions regarding your CV and integrity. I would like to start with one particular area, and that is that you filed in the past quite considerable number of complaints to the Constitutional Court. If our number is correct, there are about 22 which we counted in a respective period of time. And in your explanations, you stated that you filed those complaints. For the audience, I should clarify that these were challenging the constitutionality of certain laws or paragraphs or articles of laws. And you stated that you filed those complaints to exhaust the domestic remedies just in case the Strasbourg court one day may require this step to be exhausted in order to accept the complaint at the European Court of Human Rights. Can you please tell us more about this issue? And particularly I'm interested in two sub-questions. One is whether these complaints were results of some of your rule of law reform or legal reform initiatives, as you mentioned with de jure or others. And the second one is whether you have actually filed the complaints with the Strasbourg court in some of them.
Так, у нас стосовно
Yes, with respect to your first question, yes, I really believe that it can happen that when the constitutional complaint will be recognized as an effective remedy, that has to be exhausted before turning to the European Court of Human Rights. As I've stated in my explanations, I've written the article regarding this, I have some academic developments, I analyze the case law of the European Court of Human Rights quite often. I don't remember whether I specified that in my motivation letter, but in Facebook I'm the moderator of one of the groups which specializes on the case law of the European Court of Human Rights. And the judge of the Supreme Court created this group. He invited me to be a moderator. Now he left the group. I'm now managing this Facebook group on my own. I understand why you are asking. Probably whether I tried to get Judge Savhira so that she would take these complaints that her assistant is filing. No, I did not have this goal. And by the way, it's necessary to take into account that in the Constitutional Court and that is set out by the law and the case law. When people file constitutional complaints, they come to the unit of preliminary processing. They have separate specialists who check these complaints, whether formal requirements are complied with. They prepare a draft report, whether there are grounds for opening of the proceeding, and only then they transfer them to the judge. Every time when a person submits several complaints, they specify that in the report. For example, if two complaints are filed and they get to two different judges, both judges will know about the existence of another complaint. So it cannot happen that this judge of the Constitutional Court takes a decision under this complaint without knowing that there is a similar complaint. So I did not have this purpose to somehow get this judge. With respect to your second question, I had a very interesting case in the Constitutional Court where I was filing a claim against the Constitutional Court that was about publication of information about constitutional complaints of other citizens. We have such a practice when the website of the Constitutional Court publishes appeals of political bodies when they're challenging laws, but when ordinary people are filing complaints, these complaints are not published. I believe that they had to be published because that's the subject matter of public interest. So I filed a claim against the Constitutional Court. I partially won, and then I was challenging constitutionality of the law on the Constitutional Court. So the Constitutional Court was checking constitutionality of the law about the court itself. They recognized this law constitutional. There was only one dissenting opinion, and based on this decision of the Constitutional Court, I filed a complaint to the European Court of Human Rights. There is no decision there. It's still pending. I've just received information that the complaint has been registered. The European Court of Human Rights is working very slowly, so probably will get result in many years. But with respect to those things that you've asked, that is the case about this aspect.
You mentioned in your motivation letter, I think, that within this context of filing the cases with the Constitutional Court, you also put one sentence, which I would like to clarify. The success rate for constitutional complaints in Ukraine is extremely low compared to countries such as Slovakia or the Republic of Lithuania. Can you please tell me what data did you compare? Were these constitutional complaints filed by individuals to the Constitutional Court in general, or constitutional complaints filed by individuals to challenge the constitutionality of a respective law?
Ну, я тут розумію, що
I understand that as compared to Slovakia, this comparison might be irrelevant because you have the full constitutional complaint in your country where you can challenge court decisions and not only laws. So of course, the legal systems are different in this respect. So maybe I would not provide some statistical data. But if we're talking about Lithuania, then at once I would like to say that I'm a big fan of the Constitutional Court of Lithuania. I've been interested in the case law for many years. That's not an attempt to bribe the head of the chair of the commission, but I know statistics in Lithuania. They have 20-25 cases considered on the merits per year. And in Ukraine, the statistics is much lower. Over the recent years, maybe 5-6 cases were considered on the merits per year. This is extremely low number. And going back to my presentation, one of the aspects that makes Ukraine different from Lithuania is that in Lithuania, the correlation between those decisions where laws are recognized as constitutional and unconstitutional, that is 50-50. So in half decisions, they consider them as unconstitutional. And in Ukraine, we have 9 of 10 decisions of the Constitutional Court state that some provisions of the law are unconstitutional. And what does it say? It says that judges of the Ukrainian Constitutional Court do not accept cases where they have grounds to check the law and to say that the law is constitutional. When people raise issues about constitutionality of the laws, but instead of resolving this dispute on the merits, they at once fail to accept this case. So that is why, by the way, I believe that it is necessary to demand from inspectors to take a decision not only about bringing to responsibility, but also about not bringing to responsibility, because these decisions have a very important role in the context of explaining grounds for bringing judges to responsibility. When the ACJ refuses to bring the judge to responsibility, then it means that it explains allowed boundaries of conduct. Similarly, when the Constitutional Court recognizes the law as constitutional, then it explains to the parliament, these are your boundaries, this is where you can adopt your laws. And going back to your question, yes, I know the statistics, I've compared it, and I've also talked previously about this with former president of the Constitutional Court of Lithuania, and he also explained that their statistics is much better than in Ukraine. I can't provide specific figures now without preparation, but they have up to 10% of accepting complaints. So 1 of 10 complaints are accepted, and in Ukraine that is 1 out of 100 complaints. So if each of us now submit a constitutional complaint to the Constitutional Court, all of them would be unaccepted. So I believe that this is a problem that should be addressed and should be voiced.
My last question goes back to our first interview 3 months ago. It's about the case we already discussed, and you expressed your opinion quite clearly, but it resonated, this case or issue resonated with the society, so I think we have to reflect on that one more time. And that is the appointment of Judge Sofiria by Parliament to the Constitutional Court, and you joining her from the parliamentary assistance role to the scientific advisor at the Constitutional Court. There were doubts raised whether it was legal or illegal by the Parliament, this appointment. You stated your opinion in the documents. Can you please walk us through the process of the very moment of appointment and you being offered this job? What was going on in your head, in your mind? What were you waging when you were transferring to the new position with this same previously MP, then judge? What did you consider and what was the result?
Я думаю, то там це питання можна.
I think we connect this question with the question about moral dilemmas that you've asked quite often to other candidates. At once, I would like to say that Sofiria has never asked me about my opinion about this. And I found out that she was appointed as the judge only after she was appointed. I read in the news about this. She did not tell me that it was going to happen, that her candidacy would be considered. Back then, I decided that if I agreed to work with her as her academic consultant, then I would be able to bring more benefits. Maybe I would be able to suggest some interesting ideas in the court. So after all, I decided that this non-compliance with the law when she was appointed as the judge happened, but if other judges of the Constitutional Court agreed with her appointment, then this violation probably was tolerated. And in this respect, I can refer to other experience when in 2021 the President of Ukraine appointed two other judges of the Constitutional Court. That was a controversial issue. The question there was the authorities of two other judges did not expire, but two new judges were already appointed. The Constitutional Court adopted a resolution back then so that their oath taking would be postponed in time. So the Constitutional Court responded in such a way that it saw a violation regarding this appointment, and in order to minimize this violation, they postponed oath taking by these two new appointed judges. And in case of Savghiria, they did not do that, so obviously they proceeded based on the idea that this fact could be accepted.
From my side. Thank you.
Thank you very much. So we can come to the final part of it, of this interview, and now it's time for you to make some final comments if you wish so.
Ну, я би тут буду
I will be very brief. Previously, I've mentioned that I have watched similar interviews with other candidates, in particular to the HQCJ. It happened a year ago. It was very interesting. And now, when I've passed through this, when I've participated in this competition twice for the position of the deputy head and the head, then now when I have seen how it is happening from the inside, when I've been on this side of the table, that's a completely different experience. Now I have a new perspective on participation of other people in similar competitions. I understand that this is stressful, that this is very challenging. Your life is highlighted and covered publicly. This is very valuable experience. And regardless of further results of the competition, for me this experience has been very interesting, and I'm sure that it will help in my professional life in the future, no matter whether I'm going to work. So now I'm thanking to you for giving me the chance to have this experience. That's it.
We are coming to the end of our interview session. We will have one more candidate, and tomorrow we will make our decision on the winners of this competition, and we will announce it, I think, at 2 p.m. tomorrow. So you are welcome to watch our announcement, and good luck to you. Thank you very much for participation.
Добре, дякую.
Okay.
Добрий день, Pan Yuri. So, this afternoon session, we are conducting the interview with the candidate for the position of the head of the Disciplinary Inspector Service, Mr. Yuri Przewlotsky. Welcome, and first of all, I would like you to introduce or to remind you about the composition of our commission. I'm Rada Moliene, the chair of the commission. We have Yulia Bokova, Olena Kovby, Olga Popikova, John Ehrlich, and Pavel Zelinchik. So this interview is expected to last for about 1 hour, maybe a bit longer. And we will give you a floor to present your vision as the candidate for the position of the head. And after this, we will have a session of questions regarding your professional and leadership competences and then integrity. At the end, you will have an opportunity to say some final comments. And as you know, the interview is broadcasted. If you have any information which falls under restrictions for its public disclosure, please inform the Commission accordingly, and we will take a decision. And if you do not have any requests regarding the composition, we can start. Please, could you please speak slower so that our interpreters would translate everything that you are telling us, okay? So thank you very much. You have up to 10 minutes for your introduction.
Thank you. Good afternoon again. Dear honorable members of the Commission, it is an honor for me to be present here again, even though maybe you are not happy to see me again here, since I already participated in the previous competition for this position, unfortunately unsuccessfully, and the Commission has taken its decision, which was published upon my request, so everyone sees that it's clear, justified, and there are no doubts about its correctness. But I've made conclusions for myself, and I've decided to apply again for this new competition. Why have I done that? First of all, those shortcomings that became an obstacle for me last time are not insurmountable, but probably they were caused exclusively by my shortcomings and within the framework of a competition, and they can be addressed. I hope I have done my best to do that. Secondly, I think that the more candidates we have in such processes, the better it is. That's a good example, and increased competitiveness is a positive sign, and it provides more opportunities for the Commission as well to choose the best among the worthy candidates. Thirdly, I'm still convinced that based on my professional and personal qualities, I can be compliant with this position, and I can also be useful for the new service. And fourthly, and which is the most important for me, I have a sense of fairness and inner demand to act according to the law. As Ulpian honeste viverem nemerum vedere. And my position regarding this is consistent and persistent. This is not only my personal quality, but probably a feature of a practicing lawyer to try to achieve the goal. So that's why I have reapplied for this position again, and I hope that the Commission will not reproach me for that. Since the very beginning, in order to avoid any doubts about integrity of my actions, and in order to avoid accusations regarding equality of candidates, I have passed the cognitive testing and the practical assignment again during this round of the competition, and that is why, coming back to the essence of my presentation, I would like to say how the service of disciplinary inspectors should look like, according to my internal opinion. I believe that this is an extremely important element of the system of legal means aimed at ensuring the accountable, independent justice system. There should be fair responsibility because if everything is forgiven, then everything is cynically allowed. So there are no doubts about the need to have these mechanisms of responsibility in the judiciary. And that is why we have the constitutional body, the High Council of Justice. However, since the scope of tasks of this body is extremely significant and broad, and it is not very appropriate to combine elements of investigation, prosecution, and court. It is appropriate to have this independent structure, like the service of disciplinary inspectors. Importance of its existence and activities is conceptually clear because it lays the foundation for the disciplinary practice, and after all, it should ensure that guilty persons are punished and innocent people are not punished. There is also another aspect of importance of this service, because the current situation which we have with the disciplinary complaints in the sphere of the judiciary shows that it is difficult or even impossible to cope with the situation using available tools. So the newly established service is necessary. At the same time, this newly established service, including the management and inspectors, will have to face serious challenges and problems. They need to launch their work facing huge workload and huge responsibility. So what should be done? The answer seems to be simple. It is necessary to work according to the law and in a conscience. And of course, the head should perform the special function of practical nature. The priority steps during the launch of the service from scratch include tactical steps. It should be provision of logistical, organizational support, including premises, communication, access to necessary registers, equipment. It is necessary to create safe conditions of work. This is especially topical in the current context. It is necessary to organize orientation sessions for inspectors because all of them have different background, different experience. It is necessary to maintain connections inside the service of the disciplinary inspectors and with the HCJ. And then it is necessary to start working. Then we can focus on strategic directions and adjust operational processes. In the process of work, we need to encourage ongoing self-education of inspectors, ongoing sharing of experience, which is extremely important in order to avoid disbalance between different inspectors. It is necessary to introduce regular discussion of current problems in their professional work. It is necessary to analyze mistakes made in order to avoid them in the future. Maybe it is also necessary to assess effectiveness and efficiency of inspectors' work, to optimize methods of work, to standardize them, and to get feedback and to have ongoing communication with the members of the HCJ as the body that actually decides on disciplinary cases. This way we'll be able to organize and establish the sustainable structure that will ensure sustainable disciplinary practice and effective implementation of the disciplinary practice by the High Council of Justice.
To continue. And yeah, maybe it's so, I'm so sorry to say it, and because I know my capacity and I'm capable, and I think that I'm capable to have this, to hold this position, but because of subjective reasons, I can't continue participation in this competition, and I need to express my statement to terminate my participation in the competition. I hope that the Commission is not going to reproach me for that. I hope that the candidates which have already had interviews with you will prove their success and this competition will be successful. In the end, I would like to say my respects to each of the Commission members. I also would like to say thank you for giving me the opportunity to participate in this so respectful, so important professional selection process. Thank you.
Check if we understand correctly that you are
Yes,
withdrawing
I am
from.
withdrawing, yes. I have to withdraw. Personal circumstances.
Okay, so thank you for coming and telling in person your decision, and for this introduction of your reasoning. So thank you for participation.
Mr. Slawski, thank you very much for coming down here and for talking to us personally and letting us know of your decision.
Thank you. It was a great honor to take part in this process. It's impossible to proceed further.
Understood.
Thank you, and I wish everybody came to an end selecting the right candidate.
Thank you again. I'm not going to take more of your time. So thank you again for having this opportunity. Yes, indeed. I do not criticize anything. I agree with all decisions of the Commission. It was a huge pleasure for me.
Good luck to you. Thank you.
Good luck. Thank you.
So, dear Commission members, those who are watching this broadcast, as we had this, the last interview, we didn't conduct it because the candidate has withdrawn from the competition. So now we are making a break till tomorrow afternoon, when we will be announcing our results. And now we are going to discuss. Sorry. So the decision will be announced at 2 p.m. tomorrow. So thank you very much, and yeah, see you tomorrow.